Matter is to be placed before Honorable Lok Adalat, my lord. The file is before my lord.
My lord, may I be permitted to mention? I am for the appellant insurance company application for stay.
That's an application. And one for listing. Yeah. Have you served notice?
The matter.
Your Lordship, there are a couple of matters which were mentioned on 26th of August. Your Lordship allowed the mentioning, but it still has not appeared in the list.
No, your matters have become infructuous.
For inclusion, Your Lordship.
Please, Your Lordship, there was an interim order. It expired on 29th of August. There was a resolution that not be taken up. Immediately on Monday, I had filed an application for.
So what do you want?
Your Lordship, I want extension of the interim order, Your Lordship.
So when your matter will be called, come at that.
Very further down in the list. It is
Doesn't matter. You come
Your
up to
Lordship, if Your Lordship includes it in the list.
May I have your Lordship please mention what matter?
Namaskar, Your Ladyship. I am the petitioner in person of CRR 1649 of 2025. This case has been assigned by the
Madam, when your matter will be called, then you can submit. Call the list.
It is not included in the list. That is why I have come.
You want it to be included?
Yes.
Need him.
I have submitted the judgment order also to you. Okay, where the matter is there.
May I be permitted to mention for correction of an order? I mentioned earlier also. The portion has not been typed in the order sheet, my lord. So that
It is hard type. এটাকেও ওর ওই তার মধ্যে রাখতে হবে এটা কবে কার
I earlier once mentioned.
One, I'm for the petitioner, my lord. I've informed the state, my lord. Your lordship wanted to know.
My lord, I am appearing on behalf of the state, my lord.
Yes, sir. What prevents you to appear before the court when the matter gets listed?
I am engaged in another court, my lord. I am
I'm probably seeing you for the first time in this matter.
I have written instruction from board why it is pending before BCW. So, the latest instruction, BCW has sent us a letter saying that as because this OBCA, OBCB, this issue is pending, there is a stay on this issue by the Supreme Court in the initial matter, my lord. So, they have expressed their difficulty to go into it till the matter is settled by the Supreme Court. That is their version, which we have received a letter from them. My lord, we have been informed. My lord, yesterday at late night, I have been forwarded.
Promotion cannot be not kept in abeyance.
Well, that is what.
State is a party.
State is a party.
Yes, yes. Not necessary. State is there. It is a part of state authority. Well, we have received a letter on 20th 11 November 2024.
Your lordship also will ask them to produce the copy of the acceptance of the 81 rules, West Bengal Service Rule.
Yes, yes. Well, I have
Today I wanted his presence.
Matter may be fixed on
any day. I'll produce it, Lordship.
Let him file a report
Lordship, Lordship.
because you are narrating their version.
Yes, yes.
So let them file a report.
Lordship.
The learned advocate representing the state respondent is to file a report with regard to the status of the list of gradation.
Gradation list which was forwarded
by the
for vetting.
That is respondent number.
BCW is not respondent number.
State is made up particularly.
It is a wing of the state.
You have forwarded the gradation list. I'm asking what is the number of you,
Oh,
your response.
আমার রেসপন্স নাম্বার কত? আমি লিস্টে এসে পৌঁছাইনি। 4.
Respondent number 4,
4 and
West Bengal
4,
Secondary
4, 5,
Education
6.
Board.
4, 5, 6.
Is it West Bengal Secondary?
West Bengal Board of Secondary Education.
West Bengal Board of Secondary Education. When did you forward? In
Forwarded it long back.
forwarded
1 year back, just after your lordship's order.
4 to 6 to the to BCW.
Well, we have forwarded on 28th August 2024.
Forwarded on 28th of August 2024 to BCW. Next date we fixed on 25th of November for filing status report by the learned advocate representing.
Lordship.
And also we had a direction on the board to produce that resolution because they were also not supposed to.
I have already told her. I mean, she will.
I'll produce.
Position available.
Lordship.
Next. এটা কে মেনশন করেছে? তাহলে মেনশন করবে তারপরে লিস্টে আসবে। The instant writ petition had been listed upon mentioning by the learned advocate representing the petitioner. However, on the matter being listed under the heading to be mentioned, none appeared to represent the respective parties. Let the matter be dismissed for default. Next.
But I am for the petitioner.
Yes.
Final state led by Mr. Pinaki Dhol, my lord.
This case already order passed by Justice B.K. Saraf and also by the Justice Varadaj. The doctrine of non-traverse by the state.
In this matter, then why are you continuing with it?
They have chosen not to file any affidavit as yet.
You are saying that this matter has already been disposed of. There's a judgment. That is what you said just now.
Writ petition pending before your lordship.
Yes. Which writ petition has been disposed of?
No writ petition has been disposed of.
Just now you said.
Matter, Justice B.K. They have the doctrine of non-traverse already attracted.
What is your prayer in the writ petition? Why have you filed this writ petition?
I have filed for the so many prayers are there relating to the combined gradation list. That is an illegal thing. The private respondents are the ad hoc Bengali typist. On the last day, my lord said that the district judge is required. The last day, I do not know why it has been placed as to be mentioned. It is in the hearing board.
Chanchal.
They have lost their opportunity long back. Let the matter be disposed of, otherwise the writ petition will proceed.
Yeah. The registered judicial service.
My lord, in this matter, my lord, I am appealing for the respondent number 5.
Wait
my lord.
for some time, sir. Next.
My lord.
My lord, I am for the petitioner, my lord. My learned page appearing for the respondents, my lord. We are appearing, all affidavits are complete, let it be fixed for hearing 1 week after vacation. So before vacation, my lord, I will be deep from this station, my lord, due to medical checkup. That's why I am saying, my lord, let it be appear for hearing, fixed for hearing 1 week after vacation.
Well, actually, may I submit, Lordship? Actually, order passed on 24/3/23, Lordship, by this Honorable Court has been already complied with, Lordship, by the responding authorities, Lordship. Responding company, Lordship. Now, Lordship, let this matter be fixed for final hearing, Lordship.
Yes, I am praying for
Yes,
final
Lordship.
hearing 1 week after vacation.
If you have already complied with
Lordship.
the direction, what remains for them to agitate further?
Complete to kore diye. Contempt was
So for contempt petition.
contempt has been disposed of, Lordship. Contempt application.
I'm not complaining. Petition.
The learned advocate representing the respective parties submitted. The instant petition is ready for hearing. Next date, we fixed on 2nd of December for hearing.
My lord,
2nd of December for hearing.
Grateful,
end of
Lordship.
December.
Next,
Second of December. And for the respondent number 3, my lord.
On 3rd September, my lord junior mentioned the matter that was duly allowed, and the matter is placed today for the to be mentioned, Your Lordship. The pleadings have been exchanged. This matter pertaining to the grant of the revised pension.
affidavit in opposition was not on record. You filed it today.
My lord. Respondent number 3.
You are the answering respondent.
My.
Have you served a
I
copy
affidavit.
upon them?
Yes, yes.
Yes.
The affidavit replies filing my amendment. Let it be
Affidavit
kept on
in
record.
opposition filed by the learned advocate representing the respondent number 3 be kept on record. Affidavit in reply to the same filed by the learned advocate representing the petitioner be kept on record. Now the pleadings are completed.
Yes, my lord.
The pleadings are completed. The petition is ready.
This is
for
the matter
hearing.
pertaining to senior citizen, my lord, any day, Your
Date
Lordship.
fixed on 3rd of December.
My lord, I beseech.
3rd of December for hearing.
Deeply obliged.
I am for the petitioner. Lordship, kindly come to the last order of 20th December 2022.
No, did you file the affidavit in opposition? Affidavit in opposition has been filed.
No, no, they have to file. Kindly see the last order.
Supplement.
May I just place last 2 paragraphs? Having heard the learned advocates appearing for
No,
the
that they were granted the liberty to file supplementary affidavit. But what about affidavit in opposition to the merit petition?
Supplement affidavit not filed, but the copy has been served to my learned friend.
May I just read it? Subject to correction by my lord. The idea was that they will file supplementary affidavit. Thereafter, we will file a comprehensive opposition. If that is not the idea which my lord is carrying on, kindly give us a reasonable time. We will file an affidavit on the pleadings restricted to the writ petition, not the supplementary affidavit. I make it very clear today. They will take time to file supplementary affidavit.
Have you filed a supplementary affidavit?
Not filed, but FR. Copy served to
No, copy. Let us have a copy.
Copy.
If you
Junior of my learned friend, my lord. Kalidas, who is the junior.
So it will suffice your purpose if you only serve a copy of the supplementary affidavit upon the respondents.
That has been.
What about filing in the court?
But thereafter, I pursued the matter to be listed.
So what do you want now? You want the hearing to be done, or I'll give a date?
Yes, hearing.
Then why aren't you filing the supplementary affidavit if you have got it affirmed?
Well, let them give us a copy, my lord.
Supplementary affidavit affirmed on 23rd February, February 23, my lord.
So what prevented you from filing it in the court?
But thereafter, I pursued the matter to be listed. As the determination went before my Lord Justice Arvind Mukherjee, he did not add any matter for the hearing. For that reason, I could not.
Will you file it, yes or no?
Yes, yes, today I am.
Chanchal, you have been given a copy.
He's saying I've got no instruction. Now, kindly,
Junior
my lord,
Mr. Kalidas Mukherjee, with my learned friend, I have served the copy to the learned junior.
You have a copy?
Present my note, not with me.
You come at 2 p.m., you get a copy done from here.
Matter.
Come at 2 p.m. after he gets the copy of the supplementary affidavit.
Item number 8, I am appearing, Lordship. This is my application for restoration. This petition was dismissed for default on 1st August.
Who is the advocate on record?
Advocate on record is Miss Gitika Agarwal. Mrs. Gitika Agarwal.
Ask her to be present. Come at 2 p.m.
Lordship.
Ask her to be present. Come at 2 p.m.
Kindly bear with me for 2 minutes, Lordship. Kindly bear with me for 2 minutes, Lordship.
Ask her to come at 2 p.m. Next. ঠিক আছে. Correction of the year. Next.
My lord, I am applying for the appellant insurance company. This is my application for stay, my lord. I have filed the statutory deposit and certified copy also.
Chanchal. The appeal, the instant appeal has been filed within time and in proper form. Let the same be admitted. Two weeks after vacation.
Yes, my lord.
Within 2 weeks after vacation, you will file the remaining portion of the compensation amount.
Yes, ma'am.
Serve notice.
Yes, ma'am.
File affidavit of service. Next date, 4th of December.
Keep the book.
Next.
My lord, of the respondents.
Yes, sir.
My lord, I have placed my lord up to PW 7.
So let us conclude it today, sir.
After vacation.
You conclude it. You are, I mean, you are dealing this matter like a criminal
Will take some
appeal,
time.
sir.
Will take some time.
I believe we have gone through the evidence part.
We have already gone through the entire evidence.
Yes. So you are treating this matter like a criminal appeal. Yes, sir.
No, my lord. My lord has after vacation, people date
Because I have marked all the relevant
shall not trace the
portions
evidence any
that you, yes.
it shall not trace. But one thing I will submit, my lord. From the evidence as adduced, whether, my lord, charges as framed against the delinquent could be brought home. I am asking to myself, my lord. Kindly appreciate, my lord. First charge, big like anything. My lord, the suitcase was kept because he was in a hurry to join his, my lord, the transport post. And it was kept in the house of his colleague. So far first charge is concerned, my lord, your lordship have gone through the finding of the inquiry officer. Inquiry officer itself held that it was...
No, he has to answer what prompted the colleague to open the suitcase without his permission.
That he has given explanation because he was in hurry. He
was in hurry. He kept a suitcase at his colleague's house.
You, my lord.
Right. The wife initially refused to accept. Then also he kept it.
Not refuse in that sense. Wife said, let me talk to my husband. I am going to call my husband. On that impression, my lord, she left that particular drawing room and entered into the house. In the meantime, he kept the suitcase and left the premises. And he joined his, my lord, the post.
And
my lord, husband rushed to him. To husband, my lord, he explained. But so far first charge is concerned, my lord, the finding of the inquiry officer that it was not proved. So far second charge is concerned, my lord, your lordship have gone through the evidence. Is there any clinching evidence, my lord? I am asking to myself.
So
be that as it may, that finding was placed before the disciplinary authority. And against that, my lord, an appeal was preferred. Departmental appeal. Appeal court, my lords, set aside the findings and remanded back to the disciplinary authority. Well, that order was challenged before this honorable court and it was stayed. During the period while stay was in operation, what disciplinary authority did, disciplinary authority, considering de novo the findings of the inquiry officer, removed him from the service. Against that, my lord, we moved this honorable court. The removal order was stayed and he was allowed to join the service and he was performing, and direction was the de novo inquiry to be initiated from the stage of framing of charge. While that order was sub judice before this honorable court, again, my lord, the disciplinary authority, without initiating any de novo proceeding from the stage of framing of charge, my lord, removed him. Then the disciplinary authority, my lord, set aside that and ask him to frame charge, ask the inquiry officer, disciplinary authority to frame charge and to trial, hold the inquiry de novo. My lord, that was the subject matter of the writ petition before your lordship. What was our contention, my lord? That entire approach, my lord, the procedure as adopted by the disciplinary authority and the inquiry officer is vitiated by, what should I say, my lord, the arbitrary action on the part of the authorities. Firstly, while the interim order was in vogue, he was removed from the service. That is utterly, my lord, illegal in my humble submission. Then, my lord, this stale charges are, my lord, this stale and without having any foundation, proceed again on the basis of that stale charge as deprecated by this honorable court and the apex court. My lord, the further punishment was inflicted to, my lord, curtail his increment, cumulatively, prospectively. He served, my lord, the entire tenure of service, but he suffered, my lord, enormous pecuniary loss. He was, my lord, due to be promoted to the post of the assistant commandant, the commandant. All his colleagues and juniors were promoted. But because of this, my lord, the prolonged disciplinary proceeding, his promotion was not given. And further, my lord, his increment curtailed to huge extent and he suffered huge punishment.
Okay, sir. Thumbs up.
My lord, give me...
Sir, on the next date, I'll give you time. But prior to that, you ask your junior to prepare a short note wherein you will point out the lapses on the part of the disciplinary authority, apart from the scope where you feel that the court can reappreciate the evidence. In any way, at this stage, court cannot. But if you feel that there is any scope for interference, that point also you can check. For the submission of learned advocate representing the petitioner, who is to file a written note of argument on the next date of hearing, the learned advocate representing the respondent Union of India is present. Next date we fixed on 8th of December. 8th of December.
Could it be treated as Pathat?
It would be better, my lord. Let it be.
My lord, what I am apprehending, my lord, if in the meantime determination.
But I'm afraid of you people, because again you will write letters to the CJI that the court has marked it part-time. This is what you have done.
That happened, my lord.
Yes. So you people have intimidated me. That is why
my lord.
Here we all are agree. So therefore,
consent of both the parties. Let the matter be marked as part of the learned advocates representing both the parties. Let the matter be marked as part on consent.
My lord. On consent. My lord, bless you, lord.
My lord, item number 12 file print shot for short personal, my lord. Mr. Shutiya Chattopadhyay is appearing for WBSC.
You ask him to come. Let you be there. You be there. Take notes. Let's start.
Opportunity at last to appear before this court. Fact shortly put this, Lord, the petitioner was not engaged as a billing clerk and inspector of meter.
So will you please use the mic?
Oh, I'm sorry, yes. Billing clerk and inspector of meter. The area that was assigned to him was vast. About over 2,500 the consumers are there. His duty was to bill, make the meter reading
then bill, then they go after the consumers to collect and then report to the authorities. So, not in this process, it was going on, and a very heavy load was there. Not allegation was made against my client, the petitioner before Lordship, that he has circuitously, with the connivance of few of the consumer, have charged lesser amount, lesser unit of electricity consumed.
So what was his post? He was in which post?
Billing clerk,
Billing clerk.
meter inspector.
So he used to visit the house of the consumers.
Yes,
and then prepare the bill.
Bill and then
Now take the meter reading and thereafter prepare
that's
the bill.
it. Bills are drawn on the basis of the meter reading. Both the duties he performs. Then, Lord, as I said, the vast area, Lord, it was inhumanly possible. It was accepted by the authorities also that somebody else must be there to assist him. The allegation that was made.
He used to do it individually, alone.
Alone. That was his job only. He had no assistance at that point of time. Then, Lord, the allegation that was framed against my client was that that he, in connivance with the consumer, recorded lesser consumption of unit, and he was accepting some amount of money in order to do that. That was the allegation.
So from one consumer or from a bulk of?
According to them, 3 consumers. One came before the inquiry officer. He said he did not accept the allegations against him.
Who did not accept? The consumer?
The consumer. Consumer said, what the vigilance, when he has done it up to June 1999. And the matter allegation surfaced in September, about 2.5 months later. The consumer said,
was it detected?
It was on the basis of the allegation received by the authorities.
Who had complained?
The complainant were the witnesses.
Was it a residential unit or a commercial unit?
No, all commercial.
Commercial.
All commercial. All commercial. Then, not one of the it's an industrial area, not industrial unit and all that. The two of the witnesses called, they did not come, didn't depose. So the allegations from them could not be proved. One came and said before the authority that what I was asked to write, I have written and signed. This is the state of affair. And on the basis of this, Lord, what has been done, I was first suspended. I was suspended, Lord. Then the charge sheet was in September 1997. The reply to the charge sheet was given. Then notice to petitioner to inform about the inquiry officer was there. Then I submitted written submissions. Then a second show cause notice before disposing of the first show cause notice. So as against that, I have also, Lord, filed my oppositions. As against that, the second show cause notice was held to be right. Then there was provisions to go up in appeal. I did not go there and came before this honorable court, filed a writ petition, and during the hearing of my writ petition, I volunteered that I have a scope of appeal, so allow me to withdraw the writ application, go before the appellate authority. The honorable court granted it. Before the appellate authority, my lord, the appellate authority hearing took place, and then they have accepted and vetoed the findings of the inquiry officers. This is and the most startling fact is this, according to me, subject to Lord, the corrections by Lord.
Was there any comparative study of the bills?
No. What had happened?
What was the billing amount subsequent to his suspension? Somebody must have.
Was higher than what was noted. That was noted. Two, Lord, the charge sheet said the 2 meters were Lord tampered with. None of the meters have been produced or sent for checking by the independent authority. None. So, Lord, there is a lacuna of vital evidence, according to me, Lord, subject to be Lord, decided by Lordship. And then I will say, Lord, there were 4 or 5 complaints which were based on the charge sheet, Lord. On the basis of the written complaint, none of the complainant came and confirmed that these are the allegations I have made voluntarily. The authors of those complaints.
So the pleadings are completed.
Pleadings are complete, but I will take little time, Lord.
Okay.
The pleading to complete. So.
এখানে আদিত্য affidavit in opposition আর reply এর copy আছে কিনা একটু দেখুন।
Yeah. Yes, sir. What's that?
আছে।
Opposition oral reply did.
Okay.
The matter was not argued at length before Justice Orindam Sinha. In my lord's view, lordship would find that every day whatever the submissions, Lord, they were recorded. Now that will give a lordship and
No, they have checked it. It's there on record.
That's right.
For the submission of learned advocate representing the petitioner. Next date be fixed on 11th of December.
Tuesday, 11th of December. We are opening on Lord 23rd.
Yes, I won't be there till mid of November because I've got a circuit at Andaman.
Then we have to meet you, lordship, there. 11th of I'm grateful. 11th December, yes. Grateful.
But item number 4, may I come at 2 p.m.? At 2 p.m. As your lordship.
Next.
Yes, my lord, I am for the petitioner. My lord, actually, my lord, I have engaged Mr. Panma Mukherjee in this matter, my lord. My lord, grateful if the problem is that, my lord, because of this short time, he couldn't appear today before the lordship. I'm grateful, my lord, if my lord can fix any date after vacation. My lord.
So this is that matter where you had pointed out about that affirmation part.
No, he filed an application for it.
In that substitution application. On the prayer of the learned advocate representing the petitioner, seeking time to appoint whom? Learned advocate Mr. Tanmoy Mukherjee to represent the petitioner. Let the matter be fixed on 15th of December. The learned advocate representing the respondent, Port Trust, present. 15th of December. Next. না, এটা 18 আছে একটা।
I am for the petitioner. 18. I am for the petitioner, my lord.
Yes.
I already completed my argument. Written notes was filed. So let it be kept for reserve for judgment.
আসুন। Learned advocate representing both the parties submitted to a file with written notes of arguments. No further submission is there on your behalf?
No, my lord.
Okay. No.
Exhaustive written notes of argument.
Hearing concluded. Save. Next. Sir, what is this matter?
This is the petitioners are claiming the promotion. One petitioner in the meantime retired, so notional benefit in case of the petition number 1 and the petition number 2, the entered promotional benefits. So the case is that the petitioners were given the permission to increase their qualification, so they obtained the diploma in electrical engineering. Petitioners are claiming in the promotion in the post of chargeman by direct selection.
Okay, I've recollected. They had to submit, right?
No, I have just opened, but your lordship I just formulated the point, the facts and the case laws I did not cite. So just they sought time, whether the recruitment rule was framed in terms of the division bench orders or not. That on that point they have to submit. Otherwise, I will submit on merit also. Your lordship's specific query was before them that whether in terms of the division bench order, whether they have framed the recruitment rule. And thereafter, your lordship will proceed with the matter.
Whom are you representing?
I'm
So, where are the rules? Did you file the rules?
Any day.
There is no such order directing this. Verbally, your lordship made the query.
What I wanted them to file the recruitment rules.
Yeah, recruitment rules and whether they have already framed the recruitment rules.
For the submission of learned advocate representing the petitioner, the learned advocate representing the respondent number 2 and 3 is to file the recruitment rules in compliance of which the promotion of the petitioner is governed. And what else did I ask?
That in the verbally, your lordship,
I pointed out that there is an observation of the division bench that they should frame a recruitment rule, and your lordship query was that whether they have at all framed it as per division bench order.
Moreover, whether the concerned respondent number 2 and 3 have framed their recruitment rules abiding the direction of the division bench of this court. By order dated?
By order dated 1st of December 2011, division bench.
1st of December 2011. Next date we fixed on 16th of December. Next.
Doctor, we are representing the petitioner. In this matter, the petitioner has expired, and we are contacted his legal heirs in a telephone conversation. They are intimated to us that they no longer wanted to pursue the matter in court.
Ashok. None appeared to represent the petitioner, the learned because you are not earlier also had asked you to file a written instruction.
They haven't.
None appeared to represent the petitioner, the learned advocate representing the Correspondent Union of India is present. Let the matter be dismissed for non-prosecution. Next.
My lord, in this matter, my lord, I beg to appear on behalf of the petitioner, my lord. My advocate record is there, my lord. My lord, I beg apology, my lord. Since, my lord, the affidavit in opposition is missing from my brief, my lord, I could not prepare the affidavit notes of argument. My lord. Need, my lord, 1 week time to file, my lord, notes of
Ashok.
argument.
Notes of arguments, written notes of argument filed by the learned advocate representing the respondent be kept on record. The learned advocate representing the petitioner seeks further time to prepare the written notes as he had lost the copy of the affidavit in opposition. Next date we fixed on 24th of September for filing written notes.
Oblige, my lord. My lord, may that opposition be, my lord, served upon us at our
You
cost.
to contact my clerk, I will hand it over. No problem.
Thank you, sir. Thank you, sir. Oblige, my lord, oblige.
Matter regarding the alleged overpayment amount recovered from my terminal benefits. My lord, in the earlier occasion, your lordship kindly see on 21st of August 2025.
Where is he, Mr. Adok?
Mr. Adok is not there. And one more thing, your lordship, the name of the advocate, when a counsel appearing for the petitioner, Mr. name should be recorded instead of the others, your lordship. Lordship, junior is there.
লিখছেন এত ভুল করলে তো খুব মুশকিল। You give your name.
Lordship. Lordship, Mr. Adak Junior is there.
Lordship, he engaged, your lordship. Court number 18.
My lord, in this matter, this issue, my lord.
You had to file affidavit in reply.
And no, your lordship. This issue has already been settled. My lord has passed the order in a similar circumstance.
Okay, then I'll fix it for orders.
Lordship.
Or the submission of learned advocate representing the petitioner, none appear to represent WBMIC. Next date we fixed on 14th of November for orders. Next.
Another date?
14th of November for orders.
14th of November. I'm grateful, your lordship.
No, 31 to 37, I appeal for the petitioners, except item number 34.
No, in this matter, I am appearing on item 33, 34, 35, 36.
Yes, now what is the issue?
33, 34, 35, 36.
The written notes have been filed, it's only for hearing.
These are different matter than other matters.
These are different matters than other matters.
Yes, my lord, because
in the 6 matters, 2 matters are such where charge sheet has been issued and has been stayed by this honorable court. There is 1 matter where no disciplinary proceedings initiated and appointment has been cancelled. And there are 3 matters, 3 identical matters, where charge sheet, disciplinary proceeding, everything has been done, and after that punishment has been awarded. So these 3 categories of matters can be
Which falls under which category?
kindly segregate this matter, otherwise it is creating difficulty. My
So
lord.
you are representing the petitioners in all the matters.
Except item number 34.
Which one is that? What is the number?
Yeah, item number 34. List. I'll tell you.
আপনার junior হয়ে থাকে। আরে আরে यार क्या हो?
Item number 30, WP 7671 of 2019.
So you are not appearing in this. Who is appearing for them?
Mr. Kishore Mukherjee is appearing.
Where is he? I think it will take some time. I'll fix a proper time for this matter then.
Actually, your lordship, my humble submission, the issues relates to the separate matters. Are some different issues are there.
That is what he has said. There
Your
are
lordship, separate
Divided
matters,
into 3 groups, Your Lordship. I can indicate those groups.
separate hearings be made, your lordship.
And
Then the entire things be
and
clear
take
and
it up
entire.
my lord, separately. Otherwise it will
Not required, Your Lordship.
jam everything. It will create difficulty for us also.
Will not create any difficulty. Your Lordship will kindly,
As is the court.
as far as item 31 and 32 are concerned, same issue. As
let
far
the
as,
matter be fixed on
Separately.
19th of November at 2 p.m. On that date, sir, you segregate these writ petitions. Okay, it will be, listen to me first. It will be appearing all together, but against each number, you just mention the issue. As he said, charge sheet was issued in 2
Chart has
matters.
already been filed to that
Where-
effect.
Is it there on record?
That might be in record in one of the files. The chart has been there.
Then if it is in one of the files, it won't suffice. You file afresh.
That file is 18 November.
Yes. কত বললাম 19th November at 2 p.m.
Actually, your lordship, regarding item number 31, lordship, the written notes of argument has been submitted by the petitioner, your lordship, and thereafter I have also submitted, the respondent also submitted written notes of argument in this matter. Regarding item number 31, your
Okay, you mention that first, then we'll see.
Your Lordship,
Oh, this is that Mahadev Ghosh matter.
listটা খুলো না তোমার মোবাইলে।
Oh, now I remember. Okay, 2 p.m. 9.
Only one thing, item number 37, I find my written. Let me take it.
37 means প্রভাত
প্রভাত
কেন এত রাত কেন করছো একটু দাও না
আপনার কেন দেবো এটা কোর্টে কি হবে?
Written note filed by the learned advocate representing the petitioner, in which now you will call the item number. You tell me the number of the writ petition.
This is WPA 21108 of 2019.
21108 of 2019.
2019.
No, I think
actually this matter is to dismissal imply, your lordship, not relates to the item number 31 and 32.
I already
if
said
you
that.
should-
Can we
Told,
classify
yes,
this two
told,
groups?
yes, told. Next.
কি হলো?
The case by your lordship, the petitioner, being an person employed with the Sahastra Sima Bal as a constable, was dismissed from his services, thereafter led to suspension on the ground that the petitioner has illegally trespassed into the house of the complainant, a lady constable who filed the complaint, and was also charged for committing rape. That was the allegation. Initially, the proceedings were conducted before the criminal court under the CRPC and IPC. Thereafter, application was made and this proceeding was transferred under the General Forces Act before the General Forces Court under the Sahastra Simabal. From the criminal court, this was transferred to before the General Forces Court. Now, thereafter, the charges were made, proceedings were held. I was found guilty only of house trespass and simple hurt. I was discharged of the allegation of rape. However, in the meantime, I was already suspended from services. I challenged the suspension by filing a pre-confirmation petition under the Sahastra Simabal Act before the concerned authority. During the pendency of my challenge, they have promulgated the sentence and my sentence was confirmed. When the challenge was pending, I filed a writ petition. Now, in the writ petition, pleadings have been completed, Your Lordship. They have, on the last occasion, Your Ladyship asked them to produce the entire records of the court below before this court. At my instance, the records have been filed. Now, inspection, there was also an order for inspection of the records. That inspection has till date not been completed, Your Lordship. So, I need an extension for completion of the extension of the original records filed before the court.
What prevented you to complete it, sir?
Your Lordship, it was not completed, Your Lordship, due to dearth of instructions. The advocate record is also stationed in Jalpaiguri. He could not come, Lordship, because of his illness.
Good enough.
Lordship, I am the counsel appointed in this matter. So, he was to take instructions, he could not come. So I take it upon.
What instruction do you need?
No,
from whom
I don't.
to inspect the records?
No, I don't need it.
You have obtained.
No, I don't need an instruction. Since I am counsel appointed in this matter, I cannot come and take instruction. I cannot come and take inspection, but I take it upon myself because since he is not there, I am representing.
Because in any case, the advocate on record will be of no use to you.
No, he's obviously, Your Lordship, we need.
Because if
Without the advocate on record, we cannot.
Jalpaiguri, he won't be coming here to assist you.
I fully appreciate that, but Your Lordship, I take it upon myself. I take it upon myself, Your Lordship. I take the burden for not completing the inspection within time. But the case is like this. This is the factual circumstances on which this writ petition has been filed.
Apart from inspection, why do you need to inspect? Don't you have the documents with you?
No, all the documents are not with me. Lordship, all the case records which was filed before the court below, before the General Forces Court, all those documents are not with me. So I thought.
It's been dismissed.
I have been suspended from the services. That is under challenge. That is under challenge.
He was suspended from service. He challenged it. Then subsequently has been dismissed. That has been challenged by way of an application.
Yes, when I made the application, this is under a particular provision under 131 of the said act. When this was pending, they promulgated the sentence. This is also under challenge in the writ petition.
No, you said you had been exonerated of certain charges.
There were 4 charges against me: rape, house trespass, simple hurt, and intimidation. I have been discharged of rape and house trespass. But in respect of criminal intimidation and simple hurt, that has not been discharged. I have not been discharged from that.
And based on that, you had been dismissed.
Yes.
I mean, that is the punishment to have been imposed upon you.
Correct. So that punishment was imposed upon me. I challenged that under the act.
Was there any scope for filing an appeal by them before any appellate authority under the act?
No, we have exhausted all the remedies.
You have
exhausted the remedies after that during the pendency of the.
So there was a confirmation of that order.
Confirmation of the order, which happened during the pendency of the writ petition.
Is a pre-confirmation
and post-confirmation. So pre-confirmation I challenged by way of an application. During that sentence was promulgated, I challenged that in the writ petition. Now when the pre-confirmation petition was pending, they post-confirmed my punishment. During the pendency of the writ petition, that is also under challenge by way of an application. So the case today is like, these are the factual circumstances of this case. Now, only the record
He was
of.
also a constable.
He was
He's a constable, the petitioner.
Constable, yes.
Constable GD. And the
Complainant also a constable, lady constable. Lady constable.
No.
Huh?
Lab assistant.
Lab assistant.
Lab assistant. I am the constable, she is the lab assistant. So, Lordship, only if your Lordship kindly keeps it after the vacation, in the meantime, I will complete the inspection and thereafter, your Lordship, we can get the matter heard out. And I really do apologize, your Lordship, since the inspection could not be completed.
Do it. You have not done it. So don't.
No, I take it upon myself.
If they really want an inspection, because all the records.
No, all the records are not.
He's not prepared properly today. That is why he has.
No, I'm prepared otherwise. Factually, I'm prepared. Actually,
Actually, he is prepared, not otherwise.
Your Lordship,
This
Your Lordship
fact
can
he
hear out
had
the matter.
narrated on the earlier occasion also. Similar facts.
Your Lordship can hear out the
So
matter.
he has.
I have no difficulty. Otherwise, I have no difficulty. As far as I simply, he has not challenged any procedural aspect. His challenge is on quantum of punishment. Quantum of punishment, I have got judgment. No, procedure also have a challenge. In the report. Take, very well.
How long was he in the service?
Lordship, he was from 2007-8 he has joined. 2009. 2008.
And this incident occurred on which year?
Lordship, this 14. The complaint was lodged on 24th of August 2014. 10, 11, 12. And I was suspended on 6th of November 2017. I was dismissed from services on 6th of November 2017. After 3 years.
No, pleadings are completed.
Pleadings are gone.
Heard the submission of learned advocate presenting the petitioner who seeks further time to inspect the case records, and the same is allowed. Next date we fixed on 9th of December for further hearing. On that date, you get yourself prepared properly. Apart from the factual aspects also.
Your Lordship, I prepared today. It's not that I am not prepared. Only the inspection is to be completed, Your Lordship.
Complete the inspection and come back on that date. And in the meantime, you can also ask them to, you can prepare a short note.
If they want to rely on any document which is not on their in their writ petition or the affidavit in opposition from the inspection, let them give us a notice that we will be relying on this particular document. If I rely on something else, I will give you a notice.
But if you don't see the documents yourself, then what will happen?
No, I will see the documents myself only. See the documents myself. Grateful.
41, I am for the petitioner. 41, I am for the respondent number 1 and 2.
Yes.
National Youth Manufacture Corporation.
Which one? Which one?
Item number 41.
41.
Yes, ma'am.
How many respondents are there?
I am for 1 and 2.
Who are the answering?
Yes, ma'am. I am the answer.
Now tell me, what is it?
On the last. What has happened, my lord, in this matter? There was a direction for filing a report in the form of affidavit. That was affirmed in the year 2019. I have also served a copy upon my learned friend, but the original report is missing. That is why, my lord, I have affirmed another report yesterday. My lord, you lordship grant me leave.
And my lord may kindly appreciate that the earlier, on the basis of earlier report, which was
No, but then you go through this report, you must be having a copy of the earlier report.
just now had been handed over a copy.
So you go through the report, see whether there is any dissimilarity, and you come at 2 p.m., then I'll pass you. And then I'll accept your exception also. 2 p.m.
My lord, I'm for the petitioner, my lord, on
We are for the response.
12th June, my lord, they were in the order dated 12th June, my lord, there was a direction upon the respondents to file a report in the form of an affidavit stating how the operation profits were given to the employees from financial year 2018 to 2023. That report has not been filed yet.
So far as this matter is concerned, Lordship, we are led by Mr. Lokhi Kumar Gupta, learned senior advocate. Lordship, he is physically indisposed, Lordship. So we are praying accommodation on his ground. Lordship,
I'm not standing in the way of
he is leading us.
But ensure that on the next
Yes.
date you file a report.
Lordship, 100%.
The learned advocate representing the petitioner is present. The learned advocate representing respondent number 3 and 4 submitted that senior advocate Mr. L.K. Gupta is physically indisposed of and sought for an accommodation. Next date be fixed on 17th of December for further hearing and compliance
Lordship.
of the order dated 12/6. 2025.
My lord.
2025 Barbara Buchkan. 2025.
Lordship, this matter relates to, Lordship, the height of the petitioner was disqualified. The height which the command hospital had increased, Lordship. But now I have sought instructions. The selection process related to 2018. Lordship, now that
has been exhausted. So I'll fix it for orders. Ashwin.
Immediately, I have filed as a writ petition, my lord. When 2 times my lord, firstly my lord appeared, there my lord 170 centimeter. They are qualified. After 1 year, in decrease, my lord, height decrease. Then after my lord, an order was passed.
Okay. Heard the submission of learned advocates representing both the parties. Let's take the fixed on 20 November for orders. Next. 49. 49.
May it please your lordship. My lord, I appear for the petitioner. Lordship had the occasion to deal with the matter on earlier occasion when I argued in part on possibly convincing the court regarding territorial jurisdiction, showing Nawal Kishore Sharma and other judgments. My writ was summarily dismissed on the ground of want of jurisdiction. I preferred an mandamus appeal. Appeal court reverted the matter before the trial court once again, keeping all points open. So I must address the court on territorial jurisdiction first. That I started when your lordships found that their affidavit, which was filed, and a copy was given to me on earlier occasion, was not in the file. They filed in the department. That is why your lordship has fixed the matter today.
Department থেকে এসেছে affidavit.
Right.
Do you have a copy?
Yes. Copy, but I, proper mind, understanding goes, my lord, it has come.
It has come? Yes, it's there.
Well, I have prepared a written notes, short written notes.
No, let me go through the same thing.
এখানেই আছে, তুলে নিয়েছি। Another short point involved here, the petitioner joined in the year 1969 in Kolkata in Export Promotion Council, which is Export Inspection Council, which is under Ministry of Commerce and Industry, my lord, and it has got pan-India offices. My lord, as officer of Export Inspection Council, my lord, she retired from Cochin in the year 2003. Now, when she retired, she has given additional charge to look after the Kolkata office, some assignment. That was there. All the annexes I am not showing right now. My lord, she retired. My lord, earlier, there was she was governed under the CPF scheme. Now, after the fourth pay commission, the government has come up with a scheme of GPF that whosoever wanted to convert from CPF to GPF, they can exercise their option within a cut-off date. Well, she didn't exercise that option within that cutoff date. Subsequently, a matter was of a batch of employees preferred a matter writ petition in Bombay High Court, which says that even if you not exercise the option within the cutoff date, but you are entitled to GPF benefit since it's a beneficial legislation for the employees. It went up to Supreme Court. Supreme Court didn't interfere. I'll rely on that judgment. My lord, after retirement, she receives pension and other things in Calcutta. There's a communication from the office concerned respondent in Calcutta. That is why the territorial jurisdiction arises and she received the pension. She sent representations galore through the officers association that I want to convert in GPF. I want to get the benefit. Initially, they are of the opinion you have to return the CPF benefit which you have received till date. She has also agreed for that, provided she has had to spend also because now she is a septuagenarian lady with various ailments. So, after receiving the GPF benefit, she is agreed to return whatever she received under CPF or adjusted. That was not adhered to. Ultimately, she filed this writ petition. That is my short point. But, without going into the facts in details, but I would like to rely on 2-3 judgments. But that will cut short the matter because facts. If I show the facts, that is only they might have taken a point in the affidavit also. There is a delay. My lord, in that case, my lord, I would like to show a judgment that if my cause of action continues and it's a right, it's a fundamental right to getting pensionary benefit and benefit as an employee. So if that cause of action continues, delay will not be a bar.
But sir, you had received after substantial period of time you wanted to switch over.
Yes, after the Bombay High Court judgment, I started writing them.
But prior to that, you did receive the benefits.
Yes, I was not aware of at that point of time of that GPF scheme. And it was in 1994, I think, 1980s. So this is my short point, my lord. The judgment which I would like to rely, it's mentioned in my note. 2022 Supreme Court, my lord, Devan.
No, you are on the point of delay and latches.
Yes, delay on latches because territorial jurisdiction after Nawal Kishore Sharma, 2 other judgments I relied on, my lord, which says that writ is maintainable in where the part of cause of action arises. Article 226 2 has been explained in those judgments that part of cause of action if arises in Calcutta, I can maintain the writ in Calcutta. I reside in Calcutta, I joined in Calcutta, I receive pensionary benefit in Calcutta. There are communications from the office to me in Calcutta. So
yes, those judgments we have seen.
Yes. My lord, so far the delay is concerned on merit. না ডিলেটা দেখা আগে
শেষ করবে নাকি
করবেন my lord,
after vacation
after vacation.
You told me this judgment first.
Yes.
You cannot just, in the midst of a hearing, come to a conclusion.
Well, this is 2023 1 SCC, page 660. Para 5 to 6, I would like to test it before your lordship. Having heard so and so learned counsel appearing on behalf of the appellant and Sri so and so learned counsel appearing on behalf of the respondent state of Goa, and considering the fact that even by the impugned judgment and order, the High Court has held that action of the state government in requiring the original petitioners to retire at the age of 58 years or not, permitting them to continue in their service up to the age of 60 years is illegal and null and void. We are of the view that the High Court has erred in observing that the appellant will not be entitled to any arrears of pension, and the pensions at the revised rates will become payable only from 1/1/2020. As such, the High Court may be right and or justified in denying any salary for the period of 2 extra years to the writ petitioners if they would have continued in the service on the ground of delay. However, as far as the pension is concerned, it is a continuous cause of action. There is no justification at all for denying the arrears of pension as
This
if
is not the arrears of
Excuse me.
pension.
He is not entitled to pension at all.
not pension. I am asking for GPF benefit, which is a pension.
His benefit is a pension. How that can be?
You're relying only on this one.
No. This is so far the merit is concerned. Delay. And in merit, my lord, that's a Supreme Court decision. This is 2022 SCC online, Supreme Court, page 594. That like to place first, paragraph 20 and 21. According to the notification dated 1/5/1987, two situations were contemplated. First, the deeming provisions in terms of which the concerned employees was taken to have come over to GPF. The second situation being where a conscious option was exercised before the cutoff dates to continue to be under CPF. The case, this was a case. Batch of cases was therefore rightly allows by the learned single judge and the division bench of the High Court, as no conscious option was exercised by the cutoff date. Consequently, the concerned employees must be deemed to have come over to GPF. Logically, it would immaterial whether the concerned employees continued to make contribution, assuming himself to be covered under CPF, even though contributions were made by the concerned authority.
Sir, in these two paragraphs, nowhere it has been mentioned that the option was exercised after retirement. In this case, in your case, it has your option is after your retirement, after receiving your pension, after a certain period, after receiving all the benefits, after being in the pension scheme, receiving benefit out of it.
This says that even after the cutoff date,
Cutoff date is different, sir. You have to find out whether you can opt for this after your retirement.
yes,
That needs to be checked out. Ashwin.
well, I did not opt for this after my retirement. According to this judgment, I will automatically come under this
He on repeated
this GPF scheme.
made an option to continue under the contributory provident fund scheme. Her case is consistent case.
Whether after your retirement,
Yes.
because you have
no.
No,
you
if I
have already received the pension for a considerable period of time.
what is yes, my lord, I understand your lordship's point.
Thereafter,
My lord, only one thing.
Given, sir, it's something which we need to understand first. You had been given the word that the option was granted to you at large, to the employees at large, irrespective of the ones who had been in service and the ones who had retired.
Yes, options was given to all. There was a cutoff date. This judgment says that if you not exercise the option,
While in service,
no,
then you can do that after retirement.
no, yes, after retirement, if that was the judgment, madam, which I'm relying on.
Okay, then you show me that where
Paragraph 35, it is clearly mentioned.
35.
Yes. Well, it says that if situation arises, the employee has to return the earlier benefit. Paragraph 35, your lordship says.
So again, it says that whosoever had opted for that scheme for switching over would return the bulk.
Yes, I am ready to return.
When did you join the service? Prior to 1986?
1963, 1969. And my lord,
Okay.
and my lord, there are judgments today, my lord, I didn't bring that, which says that any beneficial legislation in favor of or notification in favor of the employees would be applied even if there is a delay.
Aditya. Heard the submission of the learned advocate representing the petitioner as well as the respondent. Next date be fixed on 18th of December for final hearing.
Well, can it be November? She is suffering in illness and other things.
Till mid of November,
Smile.
I have got a circuit.
That's a circuit.
And then the other matters have already been fixed in the month of November. So your turn.
Much of this.
My lord, this is a case of, my lord, imposition of punishment of compulsory retirement. Now, my lord, the petitioner happened to be the senior manager, and allegation, my lord, as leveled in the charge sheet. My respectful submission, my lord.
Is that the case where he had disbursed loans?
Yes, yes.
Huge amount of loan as senior manager.
That was not the fact of charge sheet. Charge sheet, my lord, I will demonstrate. Lordship, my lord, I'm grateful, my lordship, have my lord remembered the matter. No, my lord, that is the matter, my lord. Basically, the allegation was I was the instrumental in clearing the document. So far, KYC is concerned. My lord, apart from, my lord, apart from me, two other subordinate officers, subordinate to me, my lord,
were also charge sheeted, my lord, they were given a minor punishment. I, being, my lord, the senior manager.
Yes, you told this the other day.
There are a number of exhibits in the inquiry folder, more than 60.
May have, my lord, that does not strengthen his case. Now, my lord, may I, my lord, take your lordship, my lord, to the articles of charge?
Which page?
At page 70.
Yes.
Article 1. Roman 1. Fail to verify documents with originals while opening savings banks account of related borrowers, which turned out to be bogus in 9 accounts. Accepted pre-sanction inspection report wherein credentials pertaining to employment of the borrower were not verified, or accepted pre-sanction inspection report lacking in vital details, accepted property inspection report lacking in vital details wherein no due diligence was carried out in 11 loan accounts. Failed to obtain documents in support of worth declared by the borrower in CBD 23, or failed to ensure genuineness of statement of account with other banks, which turned out to be bogus in 9 loan accounts. Accepted civil reports with no hits generated prior to the date of opening of SB account in 5 accounts. Failed to ensure verification of salary slip or Form 16 from employer, or accepted Form 16 without signature of the employer. Failed to obtain IT return or Form 16 in 10 loan accounts. Failed to obtain audited balance sheet in 4 loan accounts. Failed to ensure genuineness of leave and license agreement, which turned out to be bogus in 4 loan accounts. Next page, my lord. Failed to verify the credential of suppliers and failed to ensure genuineness of quotation, which turned out to be the bogus in 4 loan accounts. Disbursed the entire loan amount on a single day without ensuring contribution of margin money of 11 loan accounts. Facilitated diversion of bank funds by transferring and remitting amounts disbursed to CD or SB account to borrower and other accounts, third-party accounts or group accounts in 5 loan accounts. Failed to ensure carrying out pre-sanction inspection.
Okay, so all these are there.
All these documents, all these allegations, rather, my lord. These allegations, my lord, my lordship, kindly visualize the situation. My lord, I, my lord, tried to, my lord, impress your lordship, my lord, the other day. My lord, the documents which are placed for verification, these documents are normally get verified by my subordinate officer, my lord, at the clerical stage, clerical cadre. Now, my lord, these of clerical cadre office staff, my lord, they get it verified with the original. My lord, make an endorsement and place before the, my lord, senior manager for final clearance. Exactly that the same things done. That includes, my lord, inquiry report, everything, my lord, that are done at the ground level and, my lord, are verified by my subordinate officers and, my lord, are placed before me, my lord, for final approval. Well, exactly those things have been done. Now, my lord, so my responsibility, I, my lord, completed that these were, my lord, just does not commensurate with my responsibilities as a senior manager of the bank. Now, my lord, next article, Article 2, that was, my lord, possibly, my lord, was not placed, my lord, last occasion. You indulge yourself in corrupt practice and gain undue pecuniary benefit for yourself or your family member by sanctioning a cash credit limit of 15 lakhs account such and such to Messrs. Binayak Electronics on 24 June 2016, transferring 2 lakhs from cash credit account from...
Yes, these were all done. Those furniture, this and that.
Yes, that part is also there. So my responsibility, my lord, these were, my lord, replied to. If your lordship kindly come to...
There was something for purchase of furniture?
Yes. That was, my lord, since, my lord, these transaction, my lord, being I'm the employee of the bank, my lord, entire transaction took place In my bank.
Sir, you just point out on the earlier date also I told you, you point out what are the lapses on the part of the disciplinary authority.
Yes, yes. Now, my lord, very interesting thing happened in this case, my lord. A preliminary inquiry was made by the bank itself, and my lord, it was referred to the concerned police station, wherein it was stated that no bank employee is involved in these affairs. I am placing it, my lord. That is also on record. Lordship, kindly come to page 63, annexure P6.
Yes.
Yes. Now, my lord, this was written to officer in charge, Jadavpur Police Station, 4th June, my lord, prior to issuance of, my lord, the charge sheet. 4th June 2019. Information furnished under section 154(1) of the Code of Civil Procedure by registering FIR against Mr. Sivani De, Mr. Alikul, my lord, some other persons who happen to be, my lord, in the records of the bank, my lord, to be the persons who are involved. Now, my lord, several, my lord, the 1, 2, 3, my lord, they in categorical manner, my lord, allegations have been leveled against those particular persons. Now, Lordship, kindly come to page.
By the branch manager.
Yes, by the branch manager. Lordship, kindly come to page 67.
Yes.
Paragraph 7, last but one. Preliminary exercise at our end to find out reasons of fraud has not substantiated the role
How
of
can
any
the branch
official.
manager find out? That is why he has sought for an
It is
inquiry.
the outcome of the preliminary inquiry done at the
Exercise at our end to find out the reasons of fraud has not substantiated the role or
of
that
any official.
that is why, but they have detected certain fraud to have been
Fraud.
committed.
But
So that is why they have lodged the complaint at the police station stating that apparently no specific role of anybody involved in the bank in
has
the
been
capacity of an employee could be detected.
Has been detected. My lord, this is, my lord, preliminary inquiry, my lord. The result of the preliminary inquiry, my lord, as my lord, came out of the later dated.
But that doesn't mean that they cannot be any. The branch manager is not an investigating officer.
No.
Akin to that of a police officer.
My lord, article of charge 24 October 2019 was issued after, my lord, 4th June 2019 later. So, my lord, article of charge, my lord, she knows it very well. Article of charge, my lord, is the result of an inquiry. Preliminary inquiry, my lord, ultimately culminates if role of any particular officer or
they have detected certain frauds to have been committed.
Yes. Now,
wrongdoings there. The articles of charge mentioned them. But they were not in a position to find out as to who had done it because apparently nobody could be specifically attributable to have been involved.
And prior to that, the suspension was issued. Thereafter, full-page inquiry was held.
And
defense has exhibited 28 exhibits. We have exhibited 126 exhibits before the full-page inquiry. Thereafter, the charter.
You had participated in this.
Yes. There is no.
28 exhibitors.
Somebody has to be made scapegoat. 28 or 128 doesn't mean, my lord.
No, Lord.
Now, Lordship, kindly come.
So you prepare a note.
Yes.
And then come on the next date because today I have these 4-order matters. Okay. So your matter will take some time, encroaching their time. And there's criminal revisional applications. So 200 matters have been given to this court. Yes, so yesterday we have disposed of 36. So probably we'll take up the others also today.
Matter may issue immediately after vacation, my lord.
Not immediately after vacation because I'll be there in the circuit. But the submission of the learned advocate representing the petitioner as well as the respondent bank. Next date we fixed on 19th of December. Written notes to be prepared by the learned advocate representing the petitioner as well as the respondents. In the meantime, yes, sir, you get sufficient time, you to prepare. Next.
My lord, in this matter, in terms of your lordship order, may I file the affidavit in opposition, my lord?
Yes. Affidavit in opposition filed by the learned advocate representing the respondent LIC be kept on record.
We have already served, my lord, all of this.
Will file. You're not there.
This is the service.
None appear to represent the petitioner. Let the matter be fixed on
Kindly, my lord, fix the application for
22nd of December. Next.
oblige, my lord.
I'm appearing for the respondent corporation, Your Lordship.
As per your lordship direction, I serve the notice to the
Yes, my lord. Yes, my lord. This is a changed brief, Your Lordship. I am appointed on behalf of the respondent corporation, Your Lordship. I'll file the wakalatnama in the course of the day, Your Lordship.
You are representing whom?
The CSTC, Your Lordship, Respondent Corporation, CSTC. 2, 3, and 4.
What is this?
Service lordship.
The learned advocate representing. Where's your affidavit?
Lordship. Lordship.
You have to file the affidavit of service. The learned advocate representing the petitioner is present. Learned advocate, what is your name?
Chahina Shuni.
Submitted to have been instructed to appear on behalf of the respondent CSTC. She intends to file the wakalatnama during the course of this week. Next date we fixed on 15th of September. You file the wakalatnama?
Yes, sir.
And then come.
Awesome.
I beg to appear for the writ petitioner, my lord. Your lordship had, my lord, on the last occasion, my lord, given the petitioner as the last chance to, my lord, file, my lord, a supplementary affidavit, my lord. My lord, that supplementary affidavit is ready, my lord. However, my lord, the concerned officer is in the court premises to get it affirmed, my lord. My lord, I will file it, my lord, get it affirmed today, my lord, itself.
Come at 2 p.m. then.
My lord,
File it and
My lord,
come
on
at 2
last
p.m.
occasion, these supplementary affidavit we have to file.
yes, we are ready with it.
But that has not been made ready till date.
Yes, my lord, it is ready.
And your lordship granted them
Doesn't
time.
matter by showing it to me. You file it and come back at 2 p.m.
No, not 2 p.m. Then we'll fix another day.
2 p.m., sir. If you can't come, ask your junior to be present. They will only file it.
Very good.
They will only file it. Claim. No. আসলে এই ক্লেম গুলো কোথায় গেল কটা থেকে অর্ডার্স ফরওয়ার্ডার্স কত নম্বর থেকে আছে 148 এটা নেই কেউ All of you are ready? Then let
Your Lordship takes that 5 minutes break, my lord, so that we call everybody.
Okay, I'll give you 10 minutes.
Lord, in the meantime, we will call everybody
Okay.
for orders. Great for you.
There's one supplementary matter as well, which is fixed for hearing with us in the supplementary list.
Supplementary? Two p.m. So 10 minutes break for you, all of you to assemble. ওখানে ওইটা লিখে দিন। এগুলো the none appeared for the parties. Let the matter be fixed on 17th November for orders. 148.
149, 150.
18th. Huh. Hmm.
151.
19th.
150.
152, my lord, we beg to appear for the claimant respondents. My lord, Mr. Afroz Alom is appearing for the appellant insurance company. My lord, he has some personal difficulties. He has personally requested to keep it matter, if possible, on 17th onwards any day. 17 onwards any day. If your lordship kindly keep it on.
None
Medically,
appear
should
to
you know,
represent the National Affluent Insurance Company. The learned advocate representing the respondent claimants are present. Next date we fixed on 17th of November for orders. Next.
May I make one humble prayer? Can it be before the vacation?
No, sir. Before the vacation, you know the position of the list, how many matters are
that is
there.
why-
This matter was appearing in the list for so many days. Next.
I have come before a lot only round of all of income.
I am for the respondent insurance company.
Landed tribunal below assess complaints and other part is correct. Malad only to this extent, malad page 27 of the paper book kindly see.
27. Yes, what happened?
Yeah, malad kindly see.
368, 20 days.
Per day. 368 per day. Malad that has been taken only 20 days. Malad second paragraph thereafter, malad. Only 20 days. My claim was, my lord, 26 days. My lord, kindly see page. Kindly see page, my lord, 83. Your lordship will find the last September 2016, my lord, payslip.
Page
83. My lord,
What can one read out of this page?
This is certified copy, my lord. Page 83, page 83. Sir. My lord, 26 days is there, my lord.
What is this? Form 9? Form?
My lord, this is September payslip of the victim.
It was marked as exhibit.
Yes,
Exhibit 15.
exhibit 15 series.
Series.
My lord, PW2.
Okay, only this point?
Only this point. Only this point. By the tribunal, you know, my claim was 26 days. And 10% will be added to as conventional head. My lord, 2022, it has been, my lord, disposed of. And claim case has been filed my lord, 2016.
When did the accident occur?
Accident took place in the year, my lord, 2016.
2016. Judgment was on
22.
22. So 10%.
10%.
Okay.
The my lord payslip and my lord page 27.
of the judgment. আমি এটা ক্যালকুলেশন করে আপনাকে দিচ্ছি।
My lord, we beg to appear on behalf of the respondent claimants.
My lord, this is an insurance appeal. It's a death case. It was on quantum. My lord, the monthly income or the yearly income, to be precise, my lord, was not proved substantially. My lord, that is why my lord was kind enough, my lord, to remand the matter back before the court below for taking fresh evidence. My lord, fresh evidence has been taken, and my lord, a supplementary paper book, which only, my lord, deals with the fresh evidence, my lord, is before your lordship, perhaps. Supplementary paper book, my lord, containing 114 pages, 114.
Which page?
Is my lord is having that, my lord?
Yes,
114.
which page?
But I was,
The
my lord,
fresh,
my lord, an employee of the company and my lord, the bank officer, they came and
page,
did.
which page?
My lord, I'll inviting your lordship now to page number 92. This is form 16, 16. My lord, instead of getting into the other nitty-gritties, my lord, the state your lordship will kindly, my lord, come.
50,000. No.
Page 92, my lord.
3,488,777.
No, my lord. The net income, my lord, the net salary, yearly salary, just prior to the death of the victim, my lord, 398,777.
398,777.
My lord, he has, my lord, got the standard deduction of 50,000. It is to his advantage. It won't be deducted. So, my lord, 34877. And my lord, the only deduction, my lord, which is
1760.
1760. Because your lordship will kindly come to the next page, my lord. The tax liability, my lord, aggregate of deductible amounts, my lord, chapter 6A. 6A also he would get advantage. And my lord, then 3931, item 12 is tax on total income, item 12. That is tax on total income, 3921. But immediately thereafter, my lord, item 13, less tax rebate.
So he has got that.
So, my lord, so he has got that. So only, my lord, this 1760 has to be deducted from the gross annual salary prior to the death of the deceased. That is 398,777. But I've shown it to my learned friend. This their paper book, my lord. So on this basis, my lord, the calculation is to be made.
ওই টিসিআরটা আসছে
বুঝেছো? Clear?
ওইটুকু এখন এনভায়রনমেন্টের উপর একটা 1700
My lord, do I make a fresh calculation and show it to your lordship, my lord?
দেখি রেকর্ডটা
এটা
আসুন
May I make one humble prayer? Though we have not filed any cross appeal, cross objection, my lord, one of the as per Pronounced judgment that since the deceased was between 50 to 60 years, that he was entitled to get future prospect on 15%. The learned tribunal has given 10% only.
My lord, it is Rashmi Cement Limited. I do not know, my lord, as far as, my lord, the permanent employment, my lord, there is any.
Permanent employment, this has come in the evidence, my lord.
দেখাও তো একবার।
কতটা পেজটা?
Evidence is in which page?
Page 3, my lord.
Page 3 of?
Page 3 of the additional evidence, my lord.
Supplementary paper.
Supplementary in the supplementary paper book.
Varunendranath Sen was our permanent
Permanent
employee.
employee.
My lord, the advantage what they are entitled to, my lord, on which I won't object, my lord, under lordship.
This Rashmi Cement, the director's authorization.
Lordship.
Earlier, perhaps there was no signature. Later on, they had sent somebody with a proper authorization. So, keep on.
কিন্তু 1100 হচ্ছে 304 380 তো করার জন্য এটাই ঘন্টা করো তাহলে
My appeal. Only on the point of quantum, a housewife, my age 69 years. My income claim blood 5,300 per month is an accident of 2017, 14th of June 2017 accident. Like tablet blood accepted on 4,000 per month. I'm not, there are 5 claimants. Like tablet blood directed 2/3, 1/3. It will be 1/3, 1/4.
Yes.
These are the all points, my lord.
Number of claimants and
Claimants 5.
what is the other part?
Other part, first income, deduction, on fourth, and not
Income part, tell me once again.
income part, claimed 5,300 per month.
For how?
It is in accident of 2017.
If it is an accident of 2017, so the income will be 5,300.
As you told me, taking in all cases. Well, house I
What have you claimed?
I've claimed 5,300.
Why have you claimed 5,300?
A house I house income I claim 5,000 or more also. Suddenly, house I'm not has some work to be valued in terms of money.
Yes. What about you?
At 4,000, I think, just because housewife, household business,
Housewife, household business.
household what? 4,000,
ঠিক আছে
and malad 1/4. 5,000 malad 5,000 malad.
Next.
Malad another one period. Malad kindly come to diyo na. Malad no.
So it's dictated now. You
No. Just PN recovery because Line Tribunal granted recovery. My lord, your lordship will, my lord, kindly come to my lord page, my lord, 19, page 19.
Why were you granted?
Because my lord, driving license was not valid. My lord, there was a clear findings of the Line Tribunal. Your lordship will find at page 18. There was a finding and
It's a pay and recovery given.
my lord, page 19, order in portion, second paragraph, last 2 lines. Order in portion, last 2 lines. And is at liberty to recover the said amount from the opposite party number 1, Sudip Kundu, owner of the offending vehicle.
Where is it?
Well, page, well, second paragraph, well, order in portion, page 19. Page 19, well, second paragraph, order in portion.
I didn't find it.
Well,
5 account being the respect and his liberty to recover the same. Learned tribunal had granted the liberty to the respondent insurance company to recover the compensation amount paid to the appellant claimant from the owner of the offending vehicle, and the same is not interfered with.
Mr. Blush, you should granted liberty. That.
Heard this matter on last occasion. Yesterday heard this.
Convinced.
At what time on 1 second for my kindly allow me to say something. For a claimant, what is to be established, your lordship, whether the accident was happened, whether the victim was sustained injury and thereafter died, and the vehicle was involved. In this case, my lord, I have established all the 3 principles. Accident was happened, vehicle was seized, driving license was seized, and the victim was ultimately died on the said accident. This has been established. But the London Tribunal has that I could not able to establish the case. So kindly read once again, my lord. This is not that the accident was not happened. Accident was not happened, but could not able to establish the case. That is not the case. Probably that is not the case. So kindly read once again the judgment. Could not able to establish the case.
This
There's a gap. There's a gap. I do admit that. There's a gap.
huge gap.
There's a gap. I do admit that. But the tribunal held that I could not able to establish. That is not, it is the dismissal was not done due to the gap or lacuna. Could not able to establish the case. You'll also kindly read once for my satisfaction, my lord.
This again is a fit case to be sent to that SIT.
Kindly send it.
Let them find out, sir.
Yes, your lord, kindly send it. Let them find out whether accident was actually happened or not. Let them find out.
Give me the details of those. You have the particulars with you?
I don't have the particulars. I don't have right now.
Have Mr. Pani has.
I'll get it now.
Let us find out what is the exact position. If their case is genuine, then they will get it.
I have no proof.
rather than dismissing it, because I'm not convinced
No,
myself.
so let them find out whether the accident was actually happened or the victim was actually died due to the accident or not. Let them find out.
I'll get the SIT particulars tomorrow and what's your value keep it.
For the submission of learned advocates representing. Is you are safe from dismissal? They can find out that you have a genuine case.
One 157, 158.
None appear to represent either of the parties. Let them- Next.
Hey, Santunda, if I 155 rupees.
Is the other side?
Mr. Subrata Bhattacharya. Subrata Bhattacharya.
Appears.
Yeah. But they are. Ini malah pasukan mana dah saya.
কত নম্বর ওটা?
Shall I come back at
After 2 p.m. 2 p.m. all these matters, let it get over. Then I will continue for orders till 3:30. Because from 3:30 onwards, the revisional applications. So maybe if
Before rising lordship, may I summon two applications lying with the lordship's code? Two files have been sent to the Lok Adalat lordship. Only direct to the officer to send the application to the Lok Adalat. Only this much. Applications, I filed two applications, kind of two appeals, lying with the before lordship's code.
yeah, that is what they are seeing.
No, record already been sent to the Lok Adalat, but two applications connected with the appeals are lying with the lordship's code. Only the application has to be sent.
Two matters for small correction.
There is one matter, Milord. Problem.
Tony.
On behalf of bank hearing already been concluded.
Just received this.
Likon. Written notes filed by the learned advocate representing the respondent bank be kept on record. Sir, you had earlier filed it. Next date be fixed on 4th of December for final hearing.
4th of December.
Next.
Last occasion, Mr. Shomo Mojumdar had advanced his argument on behalf of the petitioner. My lord wanted us to file a note. My lord, we had already filed a note before. Only, my lord, restricting to the points which was argued on the last occasion. My lord, an additional note has been prepared with 3 additional judgments.
There was any similar direction upon you?
No, my lord, because they have not concluded on the last occasion. Now
No, my lord,
today
it was
they are recording that they are concluding their submission and they are filing the additional notes, my lord.
So you conclude on the next date?
My lord, a copy may be served upon us, my lord, additional note.
Submissions filed on behalf of the petitioner be kept on record.
My lord, my learned friend may be directed to give us a copy of the additional.
My lord, he has not served his note yet.
I have not started my submission.
Next date be fixed on 12th of December for further hearing. তাড়াতাড়ি দেখুন। 4.
84 Passover.
Extremely sorry, Milord. I was stuck in a contempt matter, Milord.
What is your name?
Joyanta Samanta.
So, you see your conduct, sir?
Well, I was
On
stuck.
the earlier occasion also you were not there.
Well, I stuck in the contempt matter, Milord. Item number 1 was put number 28, Milord. That continued for some
So
time.
you have been appointed to represent the district judge,
Milord.
and this is your attitude.
But I not attitude.
On the earlier occasion also you were not there.
But no, Kalatnama has been filed on behalf of respondent.
He has been appointed by the legal remembrancers office.
Sir, I do not know.
Sir.
Kindly fix for hearing, my lord.
The pleadings are completed.
Absolutely complete.
No, my side it has not been filed, Milord.
Well, they have lost their time, my lord.
Well, I have
What
not
lost
filed.
their time?
Well, several opportunities were given.
Well, I intend to file an affidavit, Milord.
No, reply is there. Opposition is affidavit in opposition is also there.
From the respondent number 9 and 10, Milord.
12 to 24.
Well, they are the private respondents. 2 of them out of the Milord, 2 of them has retired on them. What's the
The learned advocate representing respondent number 9 and 10, the district judge Hooghly, as well as the Sheriff attached to the court of district judge Hooghly, is to file the affidavit in opposition.
My lord.
By 3rd of November. serving a copy of the same upon the learned advocate representing the petitioner. Affidavit and reply, if any, to be filed on 17th of November. Let the matter be fixed on 17th of November. Provided the pleadings are completed, and I will not give you any further time.
No. Grateful.
Yes, sir, you have. Ashwin. Supplementary affidavit filed by the learned advocate representing the petitioner be kept on record. The learned advocate representing the respondent. Who is the respondent? LIC.
Yes, one of the Union of India.
Respondent Union of India is to file a comprehensive affidavit in opposition considering the main writ petition as well as the supplementary affidavit filed today by the learned on behalf of the petitioner. Next date be fixed on 12th of November for filing affidavit in opposition. You serve a copy upon them in advance. Next.
Deep privilege.
Item number 8, take to appear for the petitioner. My advocate on record is also here.
Yes, madam.
I'm undergoing my brain and eye treatment. So on that day, I was not present. I sent my junior, but junior also could not attend it because the list was called very.
So why do you get these matters restored once you get it dismissed? And thereafter, on restoration, you continue with the same conduct?
No, madam, you can see today also I was not well, but as per
That
your
is not the issue. I mean, what have you written?
Yes, ma'am. Yes, my lord.
So,
May I hand over the copies of the medical reports, lordship?
Sponsor. The learned advocate representing the petitioner submitted to a file an application being CAN 1 of 2025, which inter alia stated due to ill health of the advocate on record, the same could not appear before the court on the earlier date when the matter was taken up on 1/8/2025. Considering the averments in the aforesaid CAN application to be explanatory, the order dated 1st of August 2025 is recalled. The writ petition being numbered 28906 of 2022 is restored to its original filing number. Now you have filed the affidavit in opposition.
Hello.
What about reply?
Reply.
Reply position to দেখতে পাচ্ছি।
Lordship, reply I am filing today. Affidavit has been completed.
Affidavit and reply filed by the learned advocate representing the petitioner on record. Pleadings are completed. The petition is ready for hearing. Next date be fixed on 16th of December.
So grateful to your lordship.
Next.
একটা কপি দিও মানে কপি মেবি সেভ টু মি
We have already given in year 2000.
Next.
Copy, sir.
One mile and I am for the petition.
But in the morning, I have filed the opposition affidavit in the form of.
Today itself you have filed? Don't talk. This is in the report you have filed in the form of. report filed in the form of an affidavit by the learned advocate representing the respondent.
1 and 2.
1 and 2. Be kept on record. A copy has been given to you.
It's been given. Well, I have checked with the previous copy. Both are identical.
So you give me
My exception to the previous report may be taken on.
the exception to the aforesaid report affirmed on which date?
It's affirmed on 1st March 2019.
2019. 1st March 2019, be kept on record. Now, you did not file any affidavit in opposition.
Well, there was no direction for filing any opposition. There was a direction for filing report in the form of affidavit.
Which date was it? Which year, rather?
19.
So this report will suffice.
I have checked.
If you don't file the affidavit in
I need-
opposition.
Yes, my lord, I need it.
No, but then what is this report all about?
My lord, according to the report, he is entitled to get the revision of pay.
So then
My lord, only after compliance of all the formalities. As per my instruction, he has not complied with the formalities.
You check into it, then on the next date we can fix it for orders. If you are agreeable to give him the
Kindly ask the authority to give me a hearing before the authority so that the matter can be decided from their end only.
My lord, according to him, he has submitted all the documents. As per my instruction, he has not submitted the documents.
What documents are required?
My lord, kindly come to his exception. Last annexure. Page 7. Kindly come to the last paragraph of page 7. Necessary form in support of the claim and the documents have been submitted for perusal and release of the payment. But as per my instruction, he has not submitted those documents.
Well, they have taken the stand in their exception that they do not have any document.
We have not annexed those documents also with this exception.
I've submitted, my lord. My lord, kindly sees page 7.
Anyway, next date we fixed on 13th of November. You mentioned the documents that they are required to submit on that date.
I will inform them.
Well, affidavit of service, my last occasion, lordship direct me to serve copy of on the notice.
Affidavit of service filed by the learned advocate representing the petitioner be kept on record.
Allora, please to grant leave to file a supplementary affidavit. It could not be arranged in the morning. Well, now it has been affirmed. May I submit with a copy to my learned friend? Copy the.
Yes.
For whom you are appearing, sir?
PSI Corporation.
Okay. Copy, sir.
Cancel. Supplementary affidavit filed on behalf of the petitioner number 1. How many petitioners are there?
Court. Mainly, court cannot be in isolation. Other 3 are there, officials.
Petitioner, on behalf of the petitioners, we kept on record. A copy of the same has been served upon the learned advocate representing respondent number 3.
PSI Corporation.
3, 4, and 5. Separately, you have served, sir.
Yes. Just now I have handed over copies.
So, any further?
Now, read petition can be heard out by my lord.
Do you want to file any opposition to this?
Yes, my lord. If after going through it, I have just been served. I will file my opposition.
In opposition, if any, to the supplementary affidavit filed on behalf of the petitioner. Is to be filed on the next date of hearing. Next date we These are 28th of November.
28th of November.
A reply also, my lord, directed.
He said, if any, if he files.
Served upon us, I will file the reply. Grateful.
আচ্ছা কি সাপ্লিমেন্টারি লিস্ট আছে?
Please, what's the matter?
Wait, let the কি এটা? You are representing whom?
Plus appellants.
Oh.
Plus the advocate in court is Mr. Joydeep Pawar.
Is it a claim case?
Yes, Milord, for enhancement, Milord.
I mean, accident
Death case.
Who is your other side?
Milord, Mr. Singh is here. Milord, the
Who
short.
is Shonna Mondal?
Milord, Sandhya Mandal was the owner of the vehicle, Milord. She was proceeded ex parte before the tribunal, Milord. We have even served it before this court, Milord. She is not appearing here as well, Milord.
You had mentioned it.
Yes, Milord.
It has come up upon mentioning.
No, Milord. Milord, it's that on the last date, Milord, the date was fixed as returnable, Milord. Milord, may have the last order, 31st July.
Now, was this heard?
Milord, it was not heard prior to this occasion, Milord.
Why have you filed the appeal? Why have you filed the appeal?
Milord, for enhancement, Milord, for enhancement of the claim, Milord, the tribunal has granted the claim amount of 3,40,000, Milord. The enhancement sought is for 40 lakhs rupees, order, Milord. The enhancement was sought because only on the point of non-consideration of the income tax returns, Milord. May kindly have the informal paper book, page number 237, Milord. That is where the only short point, Milord, impunity is there, Milord.
Which page?
Milord, 237 of the informal paper book, Milord. Milord, the judgment of the tribunal starts from 228, Milord. I'm relying on page number 237, Milord, the last paragraph. Despite income tax returns being there on record, Milord, those are not considered, Milord, and the income were calculated on the basis of notional basis, Milord. Page number 237, Milord.
Which paragraph?
Milord, the last paragraph. With regard to the income of the deceased, the petitioner in their claim have stated that deceased used to earn rupees 6,88,487 per annum. During the deposition PW1, the wife deceased could not produce any document to prove that her husband used to earn 6,88,487 per annum from his business. The alleged road traffic accident occurred on 16th June 2014, which falls within the financial year 2014-15, corresponding to assessment year 2015-16. PW2, though tendered in evidence income tax returns of the deceased for assessment year 2013-14 and 14-15, but no income tax return for the assessment year 15-16 of the SSC is forthcoming. Thus, the court has been left with no other option except to determine the annual income of the deceased on the basis of the guesswork. However, applying the ratio of Honorable Apex Court.
What is it? The documents are on record?
Yes, Milord. Milord may have.
Page.
Yes, Milord. Milord may have the page number 150 of the informal paper book, Milord. Those are the documents. 150, Milord. Those are the documents brought in by PW2, Milord, who is the income tax officer, Milord.
Okay, Chancellor.
The matter is fairly covered by your leadership judgment, Milord. I've prepared a compilation of allow me to forward, Milord.
The submission of learned advocate representing both the parties. Next date, we fixed on 26th of November for orders.
26th November for orders, Milord.
You also go through it, Mrs. Next.
Obliged.
कितने मतलब 25 के 26 का
ছেড়ে দিলে হবে। না ঠিক আছে, continue.
Deduction for
Delay in lodging complaint. Pradhan issued income certificate. 1,20,000 extra. So these are the reasons why you have come.
An unknown vehicle. Come. Stop.
Now, how many days delay in filing the complaint? On the same day. Then why are you saying delay in?
Thereafter, you will find in the it's actually one court August 22, column 2 and 3. Case of Caesar at Nolati case, district from this case at by the near that is the owner of the vehicle. Owner of the vehicle will put the vehicle with the local PS containing that yes, my vehicle was informed. That is after 2 months from the date of act. The date of act is on 23rd June 2022. The cell was done on
Yes. How much did the tribunal take the income to be?
income 10,000 the basis of income that is by the program. Page 20, the declaration of program, page 20. Cost examination question. One register is maintained in front of in respect of issue and receiving of data. Today I have not got the same register. I am not the leader of the collective that as per the resident. In exhibit 14, there is no signature of paper where Raju Sheikh was the resident. There is format in respect of income, but I have to put example featured back. And I have heard about the income condition, but they have not shown any document. It is not possible for me to take the income of the every person who resides under the Pike for a page 44 is the one income tax, less income. Page 44. Business asset income.
Another.
That is deduction, my lord. Deduction part, my lord. She will kindly come to my lord. Page 3.
The number of As I dictate, you just send me the number of pages.
Yes.
Application under section 166.
One 161. My lord, it's an insurance appeal. Page 34. Page 34, my lord. Page 34 grounds are there, my lord. Only 3-4 grounds are there, my lord. One is not well. 34. First part. Then, my lord, 4. No valid route permit. Then, my lord, they have taken 1/4 instead of 1/3.
Why? That is not, the reason is not there.
There is no valid route permit. My lord, lordship may kindly come to page 25, the judgment. Observation of the United Nations, my lord, page 25.
Route
Page
permit.
25. Relied on DW1 Tapan Kumar Majhi so that the vehicle had no valid permit after 6/11/2011. My lord, date of accident.
Did anybody come to adduce evidence?
Yes, my lord. This is the 50. This is page 21. 21, my lord. That is the evidence. DW1. My lord, they are in the affidavit in chief.
Permit was valid up to 6/11/2010.
Vehicle
When did the accident take place?
Date of accident, my lord, 15/12/2014.
Yes.
And the permit was up
It
to
is a fact
6/11.
that it is a fact that permit can be renewed with retrospective effect with payment of fine and penalty. There is no limitation to renew the permit. You don't know. This is one point. 1/4 instead of 1/3. Why are you claiming this?
They have only 3. 3 claimant is 3, not 4.
Claimants are 3.
Yes, my lord. Lordship kindly cost title of that.
Okay, 3 and then 14, 15, 45.
45. That's
So it will be 14. 14 and 25 instead of 30. Future prospect.
Permanent employee of the concern.
देखिए chapter.
Permanent employee.
Which page?
Page 15. 15.
1/5.
Second para, my lord. I have filed an attested copy of the pay slip of Tarun Kumar Nag in respect of salary for the month of June, September, October, November, December.
So what is this?
Attested copy.
So what kind of company is this? Star Security and
Private company,
Detective Agency?
Cross-examination, he has stated that I have identity card, the company to show there were 2,000 employees. Works under Star Security Service Agency. The company is duly registered before authority. And the company also has relevant documents to run the company, including police license. There is also an accounts department which looks after. So it is a established company, my lord, and he was a permanent employee. Last para, he said he would have worked at the age of 60.
Where is it been stated he was a permanent employee? Where is it stated?
When it is stated that he would have worked up to 60 years, so it can be considered. That he is a permanent employee.
How will you consider? How will you consider?
Age of superannuation is 60 years.
Where is it mentioned? What was his terms and condition? What were the
That has not been.
then in which capacity he was working? What were the terms and conditions of his appointment? Nothing is there. Only a pay slip. the deceased could have worked up to the age of 60 had he been alive.
Ten thousand, 10,000 and 10,000. 30,000 has been allowed in not.
The death case or
Yes, please. 30,000, madam.
what is the amount income it gets?
Income statement.
1,000.
Calculate 40 on third deduction.
তুমি ধরো
50%. Then it will follow, the necessity will follow. Yes.
162 is my appeal and 163 is my learned friend's cross objection. The CAN 1 is the stay application. It has probably been disposed of. Stay was it may be pending. CAN 2, my lord, there's one error in the cause title. Respondent number 1, it should be ROJIN. I have typed G. I've made an application for this appropriate order.
Which one?
In my cause title of the memorandum of appeal, my lord, this respondent number 1, it should be ROJINA. I have by mistake typed ROGINA. In place of G, it should be J. That is what my CAN 2 is.
Yes, now come to your point.
I prefer this appeal. There are two grounds, my lord. Victim was driving this vehicle at the time of accident, and it's a head-on collision between two trucks. One truck was being driven by the victim at the time of accident, and another truck, it was coming from the opposite side. So I have prayed for, it's my ground that the victim also contributed to the accident. And the second ground is, my lord, there were 4 claimants. Victim was aged around 36 years. His father, his parents, widow and minor son, they filed the claim case. So this deduction, my lord, it should have been 1/3 in place of 1/4. Now, as far as the contributory negligence is concerned, my lord, lordship will kindly come to the charge sheet once. I have taken this ground in my written statement at page 4, paragraph number 6.
Page 4.
Page 4, paragraph number 6.
Yes.
6743 is the victim's truck, and 4119 is my truck. I'm sorry, it's the opposite. 4119 is the victim's truck, and 67 is my truck. So paragraph 6, I have taken the ground that the alleged accident occurred due to the involvement of the alleged
Show me
offending.
the charge sheet.
My lord. My lord will kindly come to page 20. I'm sorry, page 20, page 25. Page 25, my lord, brief facts of the case. In the middle portion, it starts with at about 3:30 hours when they reached at 22 mile in the middle portion. Has my lord found it? Page 25. At about 3:30 hours when they reached at 22 mile under Arambagh PS area, one lorry bearing number the 6743 coming from the opposite direction and dashed their lorry directly. As a result, this is the complaint that they received, and thereafter the relevant portion is at both the drivers expired in this accident. The relevant portion is at page 29, the last paragraph, page 29, as both the accused drivers succumbed to death due to their injuries injuries received during RTA. Therefore, it will not be possible.
Eyewitness?
My lord, eyewitness did not specifically say anything. It is at page 10 that who was responsible. That specific the cross examination is at page 12, my lord. Nothing comes out specifically from the cross examination as to who was at fault. So I've prayed that the victim had contributed to the accident, and she has filed her cross. She will.
Lordships, file cross objection on the ground, Lordships. Victim age was, Lordship, 35 years.
Why have you filed the cross objection?
I'm telling Lordship, I'm submitting.
You give the reason.
Lordship, instead of 15, 16 will be multiplied because victim age is 35 years, 2 months, 24 days, not 36 years.
Where is the document?
Lordship, vote Aadhaar card also stated, Lordship.
Which page is the document?
48. 48. It is 36 years.
Driving license also.
1186.
1986. Accident is of 2022. 36 years.
36 and 35 years, 2 months, 24 days, as per Aadhaar card.
What is what had been the multiplier considered?
15. It should be 15 because this accident was of 4th of April 2022.
15. Yes, what else? She's claiming 16.
Yes, Lordship.
Then
And Lordships, general damages, Lordships also not considered. That is
30,000 given, that should be 85.
84, Lordships.
what else?
Lordships, another thing, learned tribunal judge, Lordships, consider income 9,000. But his income was, Lordship, 9,000 per month and also per day 300 khoraki. As a result, Lordship, 12,000 per month. And Lordship, page 14, cross examination also there, Lordship. Page 14, vehicle owner come and depose, Lordship. Lordships, I am not someone witness, I know. Then Lordship, he got rupees 9,000 per month as salary, including khoraki charges, rupees 300 per day. Then total.
What did the tribunal say about this?
9,000 per month, my lord.
Explanation. Which page?
Page 55. I'm sorry, not page 55.
58.
58.
Isn't Lordship.
No, page 57, last paragraph.
Last paragraph, then Lordships 58, third paragraph. Accident happened, Lordship, to 2022.
Exhibit 12 is in which page?
Just before my this.
It's 30. Page, Lordships, 49. Page 49.
Contradictions. In evidence, he says 9,000 per month. Here he says 12,000.
Including khoraki.
Yes, here. There he says.
No, 9,000 for this, only including khoraki.
But this is just a.
So accident happened 22. That may be considered.
But at least some amount, my lord, should be deducted for his contributory negligence because it was a head-on collision.
Where it is mentioned.
It's a head-on collision. I'll come to that point, the place wherein it is
Place.
mentioned. I'm coming. My lord will kindly come to page 16, the written complaint by the Khalashi. It's in the middle.
আমাদের
3:30 মিনিট নাগাদ
আমাদের বেপরোয়া ভাবে এসে আমাদের what is this?
Yes, ধাক্কা মারে।
না না আমাদের
আমাদের সজোরে
চাচিসকে সজোরে ধাক্কা মারে চাচিস
গাড়িকে
মেবি
গাড়িকে
এর ফলে আমরাও আঘাত পাই।
ধাক্কা মারে is not করবো
ধাক্কা মারে।
An application under section 166 of the MV Act had been
As a consequence, that will be late. Yes. It take more time.
Conclusion, I have taken that the cake was put state before the insurance company.
Now from 3:30, I'll be taking this revisional application. That's what I'm saying. Will it take more time?
No, not more time. I shall complete within 5 minutes. Within 5 minutes, I shall complete. First ground number was the legal ground.
You tell me notice was issued. You could not prove. Then second point. This is was a
But in the FIR, the officers will find that this shop has been doing. Not only his shop, there are 4 other shops on the roadside.
What is that?
monthly income was how much?
12,000. Take it, but
In
future prospect not added. Despite observation, that has not been
accident of which year?
2018. Yes. That will be my lord.
Your point is the income dishonor of check. 3 points. Why have you filed the cross objection? No cost. Then why were you saying? Ashwin,
No. There is no cross objection. My lord, kindly see page 37 of. Yes. My lord, kindly see future prospect is calculated 25%. It was 48 years old at the time of mistake. But that 25% has not been added at the time of calculating the compensation.
so but then it was mentioned.
Yes, sir.
Okay.
And application has to be discussed.
Yes.
They can too.
Number one, before your lordship has initiated a case of the first instance against the opposite party number two and three others, my lord, which has subsequently been culminated into an final report. And my lord, thereafter, after being discharged from that case, my lord, the private opposite party number two has initiated this case against this petitioner.
Who is representing the state?
My lord, Mr. Abhishek Sinha is appearing for this.
Where is he?
He was there, my lord. Tomorrow, my lord. I'm being led by Mr. Shondipon Ganguly and Mr. Saurabh Chatterjee. We have made our submission, my lord, and the opposite party number two is yet to commence their submission, my lord.
You have concluded.
We have not concluded, but if they commence their submission,
it a assigned matter.
Yes, my lord. Yes, my lord.
Your lordship, please, because I'll be taking up all the revisional matters.
My lord. My lord, in that case, my lord, the interim audit of stay is still today, my lord.
Okay, I'll extend that.
My lord.
Ashwin. If those matters were not there, then I could have proceeded with this. I think it will take some time. Where are your seniors? So how that makes you so happy? The instant revisional application had been fixed for final hearing on 11th of September 2025 as well as 12th of September 2025 by the order dated 4th of August 2025. However, the learned senior advocates representing the respective parties have been engaged in other courts. Let the matter be fixed on 11th of December and 12th of December for final hearing. Interim order passed earlier be extended till the next date.
You have come up for a passing of a proceeding, my lord.
Yes.
Initially, my lord, the FIR was lodged under different sections of the penal code, 120B, 409, 420, 406 of the penal code. On conclusion of the investigation, charge sheet was submitted under sections 409, 406 and 420. My lord, there was a, my lord, business transaction between the petitioner and the opposite party, and they have projected us, my lord, as a agent of theirs. As an agent, my lord, we have committed an offense of theirs.
Of the
complainant. We have been projected, my lord, or held out as an agent of the, my lord, the complainant opposite party. But that is not our license. Our license is, my lord, kindly see at page 36.
What is the state? Charge sheet has been filed.
Charge sheet submitted.
You are on all, charge sheet has been filed and it is, next date has been fixed.
No, for appearance. For appearance. Oh, for framing of charge on 13. 1310. 1810.
18?
1810. This is at the admission stage.
You had been the agent.
They have projected us as the agent, although we are not such. You will kindly see at page 36 of the brief. P1. Certificate of dealership. This is to certify that Mrs. Kalimata Builders is an authorized dealer for Captain Steel India Limited. Captain Steel India Limited is the complainant, and we have been.
This is a certificate of dealership.
So how can it be? There is we are dealings with each other, as the dealers.
Is an authorized dealer of Captain Steel.
I cannot be held out to be an agent of theirs. The 409 does not come. And moreover, 406 and 420, this is the latest judgment of the Supreme Court. 409 and 406 ingredients are otherwise, they cannot coexist together. Simultaneously, they cannot be proceeded with.
You serve notice upon the state, sir.
Yes. And in the meantime, protect us, I have prayed
for what protection do you need?
A protected for stay of all further proceedings. So this is at this small admission stage. We shall have to serve copies upon the other side, and in the meantime, the stay. As you have prayed for, your lordship, fine.
Where is the complaint?
Judgment sahib, এটা পুরো যাবে এই তো লাস্ট কপি এই তো চার্জশিট
You had made certain part payments.
Yes, paragraph 8. On their own admission, paragraph 8. I have mentioned that in my petition also. On their own showing, they have admitted this. Paragraph 8, part payment. And charge sheet is at the last page. কত দেখান কত গন্ডগোল হয়ে যাবে ফাইনাল হিয়ারিং এ রিটেন আর্গুমেন্ট ফাইল করবে তো দেখুন
The learned advocate representing the petitioner submitted to have been falsely cited as an agent of the complainant company to have misappropriated certain funds to transaction of rods. Full stop. It was further submitted that the petitioner company had been the dealers and not the agents of the complainant company without any averments as per the agreement entered into between both the parties. It was further submitted that by virtue of the dealership agreement between both the parties, certain amounts of iron rod had been procured, against which part payment was issued in favor of the complainant company, which obliterated the possibility to constitute the elements of offences under section 409, 406 and 420 of the Indian Penal Code. It was further submitted that charge sheet being number 165 of 2024 dated 31/12/2024 had already been filed, and the next date has been fixed on 18/10/2025 had been fixed for framing of charges. Full stop. The learned advocate representing the petitioner is to serve notice upon the state as well as the opposite party, de facto complainant number 2, intimating the next date of hearing and to be present, and the learned advocate representing the state to be present before the court along with the case diary. The further proceedings pending before the trial court be stayed till 10th of November. Affidavit of service to be filed to the effect of service of notice. Next.
Please, my lord. Well, this is the last matter I have before your lordship. So far, the fresh matters are concerned, my lord.
In any case, it will be till 26th September only.
Even my lord, till 26 only I have these two matters. One matter I have done yesterday, and this was the second.
Okay.
But there are two questions of law. One is, my lord, the first one, my lord, coincidentally has already been decided by the Honorable Supreme Court of India that there cannot be 420 and 406 together. Number two, whether, my lord, non-RUDs can be taken into consideration for framing of charge. My lord, this is against my discharge being rejected by the learned magistrate, affirmed by the learned revisional court. What I request to your lordship, my lord, kindly issue notice and call for the LCR. Your lordship will decide this matter. Now, my lord, your lordship is aware of, my lord, this, my lord,
no, this
Delhi Race Club, my lord, where it has been authoritatively held by the Honorable Supreme Court that there cannot be together 420 and 406 together. So this is already, my lord, a decided issue.
This is, you have come against.
My lord, I prayed for discharge. But all are known to your lordship, just as a ready record, my lord, I have just. My lord, I prayed for discharge, stood rejected, my revision stood dismissed.
The learned advocate representing the petitioner.
Petitioners, my lord, there are two.
Petitioners.
I'm obliged, my lord.
Filed the instant revisional application for setting aside of the judgment and order dated March 26, 2025, passed by the Court of Learned Sessions Judge, North 24 Parganas in Criminal Revision number 120 of 2019, whereby the order of discharge.
Or order of rejection of discharge,
whereby the order of rejection of discharge was affirmed.
Was affirmed. I'm deep.
Was affirmed. The learned advocate representing the petitioner is to serve notice upon the opposite parties intimating the next date of hearing and file affidavit of service to that effect. What else did you say?
Well, kindly call for the LCR because this requires, my lord, consideration of the LCR.
The department is to call for the TCR
Well, pending before the court of the learned ACJM Bidhannagar.
From the court of learned ACJM before Bidhannagar, not 24 Parganas, prior to the next date of hearing. Next date we fixed on 26th of November.
Most of this.
Next. None appeared to represent either of the parties. Next date we fixed on 25th of November. Next. 5th.
But I should say what is against me in this case first. Malad, this is a case in between Malad mother and son. Malad, at the behest of my sister, Malad mother has filed this 125 application, whereby I have been directed to pay 50,000. Well, it's a different issue altogether, that how much my mother holds and how much she earns. Malad, it's her income tax return which will Malad, display that how much she earns.
So you
Malad,
are
be that
not
as it
willing
may,
to maintain your mother?
not that thing. Malad, she is self-sufficient. That is one of my ground. Malad, what has
And
happened?
how
challenge-
sufficient are you?
Malad, I earn around 75,000 per month. Malad, my mother's income is 7,50,000 something per year. So it's not that, well, be that as it may. Malad, I have 50,000 has been awarded. I have challenged that order before sessions court. Malad, what has happened? Malad, your lordship would kindly come to the last page of the impugned order. Malad, the learned sessions court, revisional court, I'll say, Malad, took this as if it's a case against wife.
Come to that page where.
Last page of the brief, certified copy. Last page of the brief. 1, 2, 3, 4. Fourth paragraph starts with, at the time of hearing, learned advocate for the revisionist petitioner tried to impress upon the court that the OP wife has sufficient means and income, and since the OP number 1 is assessed under Income Tax Act, it can safely be presumed that she must be some income and she deliberately suppressed by income, and petitioner has to bear the cost of education of his own family, including the huge education expenses of his child, and the revisionist is unable to pay the exorbitant maintenance amount. Now, Marat, she is my mother, not wife. What has happened in between? I was paying regularly. There was a single default for that reason.
OP wife.
Wife. She is my mother. But perhaps revisional court thought otherwise. For that reason, this has been passed. So, but this stay has been refused. Challenging that, I am before your lordship. There is a delay of around 158 days. I'll serve and come back in the meantime. That section 5 application as well as this main revisional application. There is one development against me during this time. There was a single default. For that reason, DW has been issued. I'll regularize the payment. On that condition, kindly stay that DW. This is the order sheet. Kindly come to the last order.
Did you bring this to the notice of the sessions judge?
362, my lord. Your lordship knows.
No, I'm not on recalling. Because it might be a typographical error also.
Your lordship would see the tone and tenor of the order. Your lordship would find that. But the revisional court was under impression that she is my wife. But DW has been issued. I'll regularize the payment. It's not that I'll not pay. 50,000, I'll go on paying. The DW is required to be stayed in the meantime, and I'll serve and come back. Last page of.
You did not pay.
No, I was paying. There was a default. For that reason, your lordship would see that 75,000 was due, 60 I have paid, 15,000 was due.
So that was in the month of June. Thereafter,
Yes,
you
ma'am.
have not paid.
My lord, I'll pay. I'll regularize. I'll regularize on that condition. My lord, I'm paying for nothing. My lord, the learned revisional court will satisfy your.
Which is the next date?
My lord, 24th December. September. Sorry.
September.
24th September.
First pay and then come.
My lord,
Pay it within. Pay by Tuesday and then come.
As a lordship is, I'll do. And I'll produce the receipt before this court.
Yes. The learned advocate representing the petitioner referred to the order dated 4101/0410/2024 passed by the Sessions Judge North 24 Parganas in criminal revision number 253 of 2024, wherein the learned Sessions Judge, as aforesaid, had mentioned the opposite party to be the wife of the present petitioner instead of the same being the mother of the petitioner, under the impression that the wife of the petitioner had filed an application under section 125 of the CRPC against the petitioner hearing. The learned advocate representing the petitioner, you have come against this order, right?
Yes.
Being aggrieved by the aforesaid order, has filed the instant criminal revisional application. It was further submitted that the petitioner was directed to pay a sum of rupees 50,000 per month as interim maintenance towards the
mother.
Opposite party mother. The petitioner had deposited a sum of rupees 60,000 against arrear maintenance due from September 2024 to June 2025. Full stop. The learned trial court, by order dated 23rd of June 2025 in case number M24 of 24, had directed the petitioner to pay a sum of rupees 75,000 on 28th of July 2025. However, the petitioner failed to deposit the aforesaid amount towards payment, and accordingly the learned trial court had fixed the next date on 28th of August 2025 for payment and DW. The petitioner failed to pay the aforesaid amount on 28th of August 2024, and the learned trial court had fixed the next date on 24/9/2025 for ER of DW. D/W. The learned advocate representing the petitioner seeks for a stay of the order of 28/8/2025 passed by the learned trial court in M24 of 2024 for execution report of DW. The trial court record revealed the petitioner to be a defaulter on several occasions. The petitioner is to deposit. Now, out of 5 lakhs, how much have you paid?
My lord, as per my instruction, my lord, the amount is near around 3 lakhs as of today.
Today.
The default is in and around 3 lakhs. One thing
Is to pay a sum of rupees 2 lakhs before the trial court on by
Monday.
16th of September and file a receipt before this court to that
by way
effect.
of supplementary affidavit.
The learned advocate representing the petitioner is to serve notice upon the opposite parties intimating the next date of hearing and file an affidavit of service to that effect.
Along with
Next
CRAN.
date be fixed on 18th of September.
18th of September. Along with CRAN. I'll serve.
It's on record. Your plan. Next.
Deep law test. Deep law test.
None appeared.
Please, my lord, I appear for in serial number 210. My ladies, if this is an application under 528 for quashing of proceeding pending before the learned magistrate, ladies, if the grounds are basically lack of jurisdiction, the loans were taken at Bombay and entire cause of action had arisen at Bombay, but the bank has filed this prosecution under 25 of Payment and Settlement Act at learned magistrate, third magistrate, Calcutta.
The learned advocate representing the petitioner appeared online and challenged the territorial jurisdiction of the trial court, wherein the opposite party bank had instituted the proceedings despite the transactions being executed beyond the jurisdiction of the trial court. Full stop. The learned advocate representing the petitioner is to serve notice upon the opposite parties intimating the next date of hearing and file an affidavit of service to that effect. Next date we fixed on 24th of November. Next.
Ladies, it may stay the lower court proceeding because the applicants are from Bombay.
You are only on the territorial jurisdiction, nothing much has proceeded. Next.
My ladies, it may stay because they have to travel every time to attend the course, and the date would be in the next month.
You serve notice and then come.
211, my lord, I am for the petitioner.
Yes.
Lord, this is a unique matter, my lord, characterized by magnum suppression, my lord. It's under section 25 and 27 of the Payments and Settlement Systems Act, my lord. Now, the petitioners, my lord, procured, my lord, a housing loan, my lord, from a housing finance company, amounting to almost rupees 2.43 crores, my lord. Now, that was procured, my lord, on March 28, 2023, my lord. Thereafter, my lord, with regard to the property, my lord, for which the loan was procured, my lord, that property, my lord, was found to be, my lord, in deep waters, my lord. The documentary records pertaining to the property, my lord, were not clear, my lord, as a result of which the property was not transacted, my lord. On that score,
show me the complaint first.
Complaint, my lord, your lordship will have at page 24.
Yes.
Lordship has seen the
So
date of
you are Tanuj Kumar Garg
deeply obliged.
and you have failed to pay the installment
Failed to-
amount of
failed to pay-
1,76,828.
I'm deeply obliged. I have failed to pay the installment, Miller. Now your Lordship will see the date of the dishonor. It's August 12, 2023, admittedly from the complaint. Thereafter,
No, the transaction was unpaid on 3rd of August 2023.
3rd of August, I stand corrected. So it was 3rd of August, the transaction was unpaid, Miller. Thereafter, they have sent me a demand notice dated August 12, 2023. Your Lordship will find it in paragraph 7, Miller.
Yes, then
prior to this, Milord, I have already tendered them a letter dated July 4, 2023, 1 month prior. Your Lordship will have the letter at page 54, wherein I have narrated everything. The fraud that was perpetrated, Milord, on account of which I had to lodge an FIR, Milord. The police had registered an FIR. Charge sheet stood subsequently filed in that particular proceeding, Milord. And I had also, Milord, in that particular letter, in fact, requested the complainant to not only recall.
What is the scope of the fraud? You have obtained loan.
I have obtained loan, Milord.
Then what happened?
The housing company, Milord, also is accountable for the due diligence, Milord. The housing company, Milord, is also accountable for the due diligence. Now, your Lordship will see one interesting thing. I have been the victim of fraud, right, Milord? Thereafter, I had sent a letter, a prior letter 1 month ago, requesting.
What was the, why did you obtain the loan?
To buy the house. To buy the house. Thereafter, after I had paid
off the house from the complainant.
Not from the complainant. From
Then
a third
from whom?
From a third party. This is a housing finance company. The housing finance company had tendered me the loan so that with that particular amount of loan, I could buy the house. From a third party.
So L&T has granted you the
I am deeply obliged. It has granted me the loan. Now, thereafter, after procuring the loan and after paying it off to the third party, I realized that I have been victim to a fraud. I register an FIR against that third party. I request the complainant video notice requesting him to withhold the loan and not to encash the 4 security checks and also to cancel the ECS for some time and realize the money after it is seized, Milord, by the police. That letter is dated July 4, 2023. Subsequently, Milord, on a malicious count, Milord, they do not stop with it. They, Milord, get the payment dishonored, Milord. They send me a statutory demand notice. I even reply to the statutory demand notice, Milord, which is on record. Your Lordship will have it at page 129. Therein, Milord, reiterating my previous version, Milord, and again telling them, Milord, to withhold the loan for some amount of time because I was completely bankrupt.
Was the complainant a party to your transaction between the housing company?
The company was not a party, but the company has participated in the proceeding and secured the seized amount. Your Lordship will see it at page 188, the money release order. So the company, Milord, the complainant company, Milord, is both playing behind as well as in front of the bush. Bullshit. Your Lordship will have it at page 188, the money release order, in connection with the FIR case, which I had registered. The relevant portion of the order I will just show, Milord. The last portion of the order. The third paragraph your Lordship has seen. May I place it, Milord? Heard the learned counsels on the application and perused the case diary and other relevant documents placed on records. The charge sheet has been received in FIR number such and such against the accused viz. Pawan Kumar Singh and Surendra Singh. So these are the third parties from whom I have purchased the property. The applicant has also presented before the court a copy of letter sent by Tanuj Garg to L&T Finance Limited. So applicant happens to be the complainant company. So with the letter, Milord, which I had sent them, thereby requesting them to withhold the loan, Milord, they now use that letter, Milord, before the court below, in which Tanuj Garg has intimated the L&T regarding fraud and requested to stop the payment, in which he also said that L&T can recover the said amount as and when police catch hold of these fraudsters.
So it is passed by additional civil judge Ghaziabad. Why have you come here?
I have come for the quashing of the Payments and Settlements Systems Act proceeding, which is registered here. This, Milord, happens in the FIR which I registered. In the police case, which I have registered, my lord, with the UP police, they are participating and they have got the money.
So where did you intend to purchase the property? At UP?
UP. Because I am
taking money from them here.
No, this company is a pan-India company. They opt.
Which it can be a pan-India company, but it has to have a branch.
I have taken loan from there. I have taken loan from there. Nowadays, there is electronic loan, milord. E-loan documents, milord. This is completely harassive, milord, and I am covered by the latest Supreme Court judgment. Your Lordship knows better than me, pronounced by Justice Abhay Oka, milord. Where, milord, on suppression of the reply notice, the whole NI Act complaint was quashed. They have suppressed everything. And in UP, milord, they are playing in front of the bush. Here they have suppressed everything. Not a single line your lordship will see regarding my prior letter or my reply to the statutory notice. Not a single line they have pronounced. Just seize the complaint once, milord, if your lordship so pleases. And they have also got their money recovered.
Your application, your petition under section 205 CRPC has been allowed?
205 allowed. 205 allowed.
You issue notice. Where is the impugned order in proceedings? The learned advocate representing the petitioner submitted to have filed the instant revisional application for quashing of the proceedings of the complaint case being CS /124078 by 2023 under section 25 of the Payment and Settlement Systems Act 2007, pending before the Court of Learned 16th Judicial Magistrate at Calcutta. The learned advocate representing the petitioner contended that the opposite party, being the L&T Finance Limited, being aware of the fraud to have been committed by the third-party housing agency with regard to third-party individuals with regard to a purchase of a house, purchases of a land from the aforesaid third party, obtaining loan from the opposite party L&T Finance Limited, based on the letter dated. You had pointed out one letter that you had informed them about the fraud committed. 4th of July 2023. Asking the opposite party to withhold to recall the loan agreement and not to proceed with the The check was deposited. Proceed with the encashing of the ECS. Proceed with the encashment of the ECS. The opposite party had also been a party before the court of AC, that Ghaziabad court. Additional civil judge, second court, Ghaziabad. It was further submitted that the opposite party, being aware of the facts and circumstances of the fraud to have been allegedly committed by the third party, maliciously filed a complaint case against the petitioner. Full stop. The learned advocate representing the petitioner is to serve notice upon the opposite party, intimating the next date of hearing, and file an affidavit of service to that effect. The proceedings pending before the trial court being 16th Judicial Magistrate at Calcutta. We stayed till 12th of November. Next. Wait, 212 also the same thing.
The same. It was the ECS, and in ECS given lots, it was the check. Both checks which were deposited as security in cash. Are completely valid. Similar malicious.
The department is to tag CRR 2506 of 2025 along with CRR 2507 of 2025, wherein the cause of action are nearly similar to each other. The order passed in CRR 2506 will be applicable to the CRR 2507 of 2025. You serve notice and then come. Next date we fixed on 12th of November. I said applicable with regard to this. Next. What are you claiming? Expeditious hearing?
Yes.
The learned advocate representing the petitioner submitted that the proceedings being complaint case number 27777 of 2019 pending before the Court of Learned Metropolitan Magistrate, 11th Court, Calcutta. What was the last date?
Next date is 7th October 2025.
Then why have you come for expeditious hearing?
Lordship, the compensation amount was interim compensation was direction by the learned court, Lordship, to the opposite party. Till date, they have not payment regarding this amount, and the amount was directions was, Lordship, kindly see the order sheet, Lordship,
Yes,
6
sir.
March 2023, Lordship. And the evidence has not been concluded.
Had been fixed on several days for recording of evidence and payment of rupees 9,22,030 as interim compensation by the accused persons by the order dated 6/3/2023. Till date, the accused persons have not released such and or deposited such payment before the court, and the trial court has fixed several dates without taking any necessary steps for implementation of the order of payment. The No, you have annexed here the order till 24th of February 2025.
Yes,
After that, what happened?
I have informed that this is the last date, and then
Acha,
there are
the registered judicial service is to seek a report from the Court of Judicial Magistrate, 11th Court, Calcutta, annexing a copy of the order sheets order dated, copy of the order dated 6/3/2023. With regard to the status of the compliance of the same till date. A copy of this order is to be communicated to the trial court at once. Next date be fixed on 17th of September for report. Next.
October, Lordship. 17 October 2025 is fixed.
Next. Same order. Court is the same.
Yes.
And amount is also the same.
Amount is the different.
তাহলে amount টা দেখি কত amount? ওই রেকর্ডটা দিন। The order date is also same.
Order date is same. March 2020.
আগেরটাতে যেটা ছিল না 6 Which page is it?
The certified copy of the order, Lordship.
Second is the 11 1190 000 আলাদা হবে, হ্যাঁ। Next.
I'm appearing for the petition in this matter. Because you have prayed for quashing of the charge sheet under section 498A, 307, 323, 406. My lord, the petitioners before your lordship is the husband and the father-in-law and the mother-in-law. Now, lordship, since 307 was there, they were arrested and the petitioner number was in custody for 33 days and the petitioner number 2 and 3 were in custody for 8 days, my lord. Subsequently, my lord, in the month of February, charge sheet was filed. February 2024, the charge sheet was filed. Till date, the charge has not been framed. And another point, lordship, even though an allegation for attempt to murder was raised by the de facto complainant, my lord, in the charge sheet, my lord will find that there is the Caesar list says the descriptions of all the articles those falls under the section of 406 which were recovered. That is in the invest. Apart from that, there was nothing and no medical examination was done after the lodging of the FIR by the police authorities. Only one document which has been said to be the medical document was submitted by the de facto complainant that she got treated in her private capacity, my lord. And during
the learned advocate representing the petitioner submitted the petitioners implicated under section 498A by 323 by 307 by 406 of Indian Penal Code and section 3 and 4 of the DP Act had been granted bail by an order dated.
The bail order is at
bail by the trial court and on completion of the investigation, charge sheet has been filed being number 16 of 4 pertaining to Panrui Police Station case number 126 of 2023 dated 8/28 dated 10/9/2023. The charge sheet was filed on 28th of February 2024. However, till date, charges have not been framed. The petitioner wife has filed a false and frivolous complaint against the petitioners, causing hardship to the same. The learned advocate representing the petitioner is to serve notice upon the state respondent as well as the opposite party wife, intimating the next date of hearing and file an affidavit of service to that effect. Next date we fixed on 26th of November. Next. None appeared to represent.
But I have not received it.
Are you engaged? Have you been engaged?
Yes, my lord.
Where's your engagement letter? None appear to represent either of the parties. Let the matter be fixed on 27th. What's your name?
Mary Rotto.
None appear to represent the petitioner. The learned advocate representing the Respondent Union of India is present. Next date we fixed on 28th of November. Next.
And the Shomrat Puri is appearing in the petitioner lordship. Some relative, father of the relative was died today. So that's when he not came before this court lordship. So I'm just praying for not to do.
None appear to represent either of the parties. Next date be fixed on 1st of December. Next. Yes, sir.
18. 18, my lord. I am appearing on behalf of the husband petitioner.
Hmm.
My lord, this divisional application is, my lord, against the order passed in an application under section 23 of the Protection of Domestic Violence Act, my lord. Protection of Women from Domestic Violence Act, my lord. The petitioner, my lord, filed an application under section 12 of the Protection of Women from Domestic Violence Act and also filed an application for monetary relief, my lord, under section 12. Initially, my lord, that application was allowed in part. My lord, the interim maintenance was refused and the residential accommodation was given by the order passed by the London Judicial Magistrate. My lord, challenging the said order, my lord, the petitioner husband preferred criminal litigation, and that criminal litigation was disposed of by this impugned order. I am inviting your lordship kindly come to the impugned order, my lord.
Which page?
Impugned order dated 28th of March 2025. 28th of March 2025.
The husband appellant is directed to pay a sum of rupees 5,000 per month to the aggrieved.
That is ordering portion, my lord. My lord, if your lordship kindly come to
Disposed of with the above, the order impugned is otherwise not interfered with. The payment of shall be made. Yes.
Your lordship kindly to come to the judgment portion, my lord. Page number 2. Is satisfied with the order dated 9th of May 2024 passed by the London Magistrate under section 23 of Protection of Women from Domestic Violence Act. The instant appeal is filed. In the instant case, the aggrieved party wife is an employed person. She has her own source of income from her job as Lady Civic Volunteer Police. Although the aggrieved party claim that her husband has business of car hiring having income of rupees 1 lakh per month, but the husband stated in his affidavit disclosing his income is 15,000 per month as a taxi driving job. In the impugned order, no interim money relief in favor of the wife was granted as per section 20 of PWDV Act. However, the husband was directed to provide residential accommodation to the wife in the matrimonial home at 11 Koilas Banerjee Lane, Howrah.
It is found that the aggrieved party filed her affidavit such an assets and liability. In her affidavit, she stated that she had no income of her own. However, it is subsequently discovered that the aggrieved lady is employed as civic volunteer police, having her own salary income. So it prima facie found that aggrieved party did not come in clean hands. Now it may be opined that the learned magistrate has rightly decided in refusing to grant interim without going into the merits of the case in details and in the light of evidence. However, in the event of the order shared or frustrated, the aggrieved party may be. Yes. What happened?
My lord, challenging the said, my lord, the petitioner.
Serve notice and come.
My lord, in the meantime, my lord, kindly pass and
Serve notice and come, sir. Yeah, the order is quite conspicuous. For the submission of the learned advocate representing the petitioner who contested the order passed by the Sessions Judge Howrah dated 28/3/2025.
What is a civic volunteer and earn rupees, my lord, 8,000 something, my lord. On the other hand, my lord, the
Directing the
husband is a
husband
taxi driver.
Directing the husband opposite party to pay a sum of rupees 5,000 per month to the petitioner for alternative accommodation in lieu of a provision for shared household accommodation. It was further submitted that the petitioner wife did not have any independent means of employment and further sought for monthly maintenance. Full stop. The observation of the Sessions Judge Howrah in the impugned order that the petitioner, that wife, did not approach the trial court with clean hands required the presence of the husband opposite party. In full stop. You TCR be called for also because the assets and all are must be there. The learned advocate representing the petitioner is to serve notice upon the opposite party husband, intimating the next date of hearing and file an affidavit of service to that effect. The department is to call for the TCR from the concerned court. Next, which court is it?
Howrah. Sessions Judge Howrah.
Session Judge Howrah will not have the TCR. From the Court of Learned Magistrate, Third Court Howrah.
Third Magistrate, Third Court Howrah.
In connection in Miss Case number 518 of 2020.
518 of.
Next date be fixed on 2nd of December. Next.
My lord, in the meantime, my lord, kindly give me some.
Nothing doing. Next. You come and say all sorts of nonsense. Next.
20.
Oh, none appeared to represent either of the parties. Next date be fixed on 1st of December. You are there in 219? Oh.
Right, please, your lordship. But these petitioners have come before your lordship, my lord, challenging the entire proceeding. But the case was registered, my lord, very unfortunately by the informant who happens to be the second wife of the petitioner number 1. And my lord, there was an allegation in respect of her own biological daughter, my lord, where she alleges that on a particular day, my lord, the petitioner number 1, my lord, the case has been registered under 6, 17 and 18. I will show from the face of the record, my lord, that, my lord, so far as if your lordship takes the...
Is the advocate Mr. Mofakrul Islam, he belongs to Raiganj?
But this is most probably.
The instant revisional application be released. Itahar.
Right.
On personal grounds. Next.
I'm briefing.
None appear to represent either of the parties. Next date we fixed on 3rd of December.
Allah, I'm withdrawing this instruction. Not pressing the application.
Have you signed?
Yes, the client has given instruction.
No, no, you sign it and give your registration number. Who is signing it? The advocate? The learned advocate representing the petitioners submitted a written instruction whereby the petitioners indicated the unwillingness to proceed with the hearing of the instant revisional application. Let the same be kept on record. The instant revisional application is dismissed for non-prosecution.
This is my application for quashing of our proceedings, charge sheet, the impugned charge sheet. Under section 11, 341, 323, 504, 506, and 30 of the Indian Penal Code. My lord, the rival party of our Waqf board, my lord, alleged that by virtue of a forged document, we are trying to take over the management of the Waqf or running the management of the Waqf. On being asked under section 91, notice has been issued to them, but they failed to produce any such document which allegedly forged by me. My lord, this is the main issue, my lord. Page 5 of the charge sheet, my lord, certified copy annexed, my lord. My lord, it has been written from the, my lord, I got it from the report of the IO, final report of the IO. My lord, from the third line. Impugned charge sheet, page 5. Certified copy is there. I further issued third line. I further issued notice under section 91 CRPC to the complainant to produce more evidence of this case if he has, but he informed me that he has no more evidences.
I also asked the complainant to produce relevant documents of generator.
That is the main issue that has not been produced.
Okay. You serve notice, sir.
So, my lord, others, unless an interim order will be granted, but trial will be proceeded, my lord.
No.
My lord,
The
what
learned
is the date
advocate
fixed, my lord, and my
representing
lord,
the
the date and
petitioner
time be fixed.
is to serve notice upon the state respondents. And
de facto is all the
only state.
Yes.
Only state. De
No,
facto
de
is
facto
also
is
there.
also the party.
Also, an opposite party de facto complainant intimating the next state of hearing and file an affidavit of service to that
My lord,
state. We fixed on 14th of November.
14th of November.
Next.
I'm good.
No, I prefer the petitioner. Well, by this revision application, the petitioners challenge were the two orders dated 19 December 2024 and 4th March 2025, passed by the learned executive magistrate Bidhannagar. Well, if proceeding under section 125 was initiated for with the apprehension that the railway authorities and the KMD is trying to dispose the petitioner from their own property. Checkered history is involved in this case, my lord. In the year 1956-57, my lord, the property was acquired. Now, my lord, the landowners approached this honorable court, my lord, by way of writ petition, and my lord, this honorable court was pleased to quash the, my lord, the entire acquisition proceeding. Since then, my lord, the petitioners are, my lord, in possession with respect to their own property. Now, my lord, the KMDA and, my lord, the railway authorities, my lord, without any acquisition proceeding, my lord, have taken steps for, my lord, making of construction of road and, my lord, the railway track over our land. My lord, we approached the landed executive magistrate with the apprehension that we are forcefully dispossessed. Initially, my lord, the landed magistrate was pleased to pass an interim order. But, my lord, subsequently in the next order, without any rhyme or reason, my lord, he revoked that order. Although, my lord, the landed executive magistrate called for report from the, my lord, police and the, my lord, the BLRO. BLRO and the police, my lord, submitted report categorically stated that yes, the land is being used by the railway authorities and the KMD. But no relief has been granted by the, my lord, the landed magistrate. Lordship, kindly have a look, my lord, page 9.
So you serve notice and come, sir. You
In the
serve
meantime, my
notice.
lord, interim order, my lord, because, my lord, they are,
You have a checkered history and it's pending for such a long time, it won't affect.
not
the
long time, my
learned
lord, 24,
heard
my
the
lord.
submission of learned advocate representing the petitioner who is to serve notice upon the opposite parties, intimating the next state of hearing and file an affidavit of service to that effect. Next date we fixed on 7th of November.
And no further construction only.
Next. Not in a criminal proceeding, sir. Next. None appear to represent either of the parties. Next date we fixed on 10th of November. Next.
It was taken up by your
Yes.
yesterday.
Copy of the order?
Yes, my lord, Mr. Ghotok has given me, assisting me.
Your lordship was supposed to appoint me
that's
for state, my lord.
Yes.
That is the server
Next
copy.
date is fixed on 12th of September for
12th of
charge.
charge.
they are asked to present personally, my lord, in a proceeding. My lord, they are.
Yeah, you are for the
Madam-
person who Madam's sister-in-law who is residing in
different cities in Uttar Pradesh. No.
How can a single lady? I mean, they have what are you saying?
Three sisters.
But you have come up for one sister or
Three sisters. Three sisters. Our marriage took place much before our brother's marriage. Brother's marriage was in 2022. She left the house in 2025 and lodged a complaint in Pornosty police station. Incident took place in Bangalore. Both of them are IT engineers. Incident took place in Bangalore, and the bail order says, I have shown the bail order that nothing has been found by the magistrate in 160 by the Sessions Court in 164 that which incriminates the in-laws. Page 47. I have shown your lordships on last occasion.
so what are you seeking now?
Absolutely
Exemption from personal appearance before the court. No, that
stay, my lord, stay.
Charges will
the who are the petitioners here? All of them are married sister-in-laws. The learned advocate representing the petitioners submitted that the complaint filed by the opposite party number two dated
Complaint dated FIR dated
10th of April
10th of April
10th of April 2024
8 months after she left my house.
falsely implicated the petitioners who had been the married sisters-in-law of the petitioner. Sorry, of the opposite party wife.
Opposite party husband.
Wife.
Opposite party wife. Opposite party wife. Yes.
Opposite party wife. Full stop. The petitioners herein had been married long before the marriage of the opposite party wife, residing in their respective matrimonial homes in the state of Uttar Pradesh. The opposite party wife married the brother of the petitioners in the year
25th November 2022. 25th November 2022.
25th of November 2022. Full stop. Both the brother of the petitioners as well as the opposite party wife resided in Bangalore.
January 2023 onwards. From January 2023 onwards.
From January 2023 till the date the opposite party wife she deserted or she left or
left on 25th of August 2023.
She disassociated herself from the company of her husband on
25th of August 2023 and
25th of August 2023. After a lapse of 8 months, therefrom, the opposite party wife had filed the complaint on
10th of April 2024.
10th of February 2024.
April.
10th of April 2024 against the husband,
and all parents-in-law and the
parents-in-law and the married sisters-in-law.
He also filed a matrimonial suit for divorce in Alipur.
It was further submitted that the opposite party wife had filed a suit for
nullity.
Suit being number
Matsuit number 1136 of 2020. Matsuit number 1136 of 2024.
Matsuit number 1136
of 2024.
2024. 24 seeking dissolution of the marriage on the ground of nullity. Full stop.
That page 59.
What is this lease agreement that you have filed? You have filed a lease agreement?
To show that they were residing.
Residing in Bangalore.
Yes.
The documents on record prima facie portrays the petitioners to have not resided with the opposite party wife. In the same residence. Full stop. The next date is fixed before the trial court on 12th of September 2025 for personal appearance of the for framing of
Appearance and consideration of charge.
এটা পড়ে গেল এখানে. You have that copy,
Yes.
for personal appearance of the petitioners and for framing of charge.
In charge sheet, nothing has been, or not a single statement against them in-laws.
There are statements. So don't you want to see the case diary I have today? But
No, but I have seen the statements recorded under 161.
general omnibus are
General and omnibus,
against the husband.
mainly against but now at this stage it cannot be.
Has not been compliant. 406 has not been compliant.
Not against us.
In the FI it is there that
the
all have restraining the Sridhorna.
The general
Active role of the present petitioners with regard to the statements recorded under section 161 of the CRPC prima facie doesn't reveal their involvement in the alleged offense at this juncture.
or even in 164.
164 copy is not there, but 161 is.
I have an
Which page?
Page
The case
53.
diary is also there.
Page 50?
The complainant
As
said-
well as 161 CRPC as well as section 164 of the CRPC. The proceedings of the case Pornoshi Police Station case number 211 of 2024 dated 10/4/2024 based on the complaint lodged by the opposite party wife against the present petitioners under section 498A by 406 by 307 by 34 by 506 by 509 of the Indian Penal Code is read with section 4. 3 is not there. Section 4 of the Dowry Prohibition Act 1961 is stayed against the present petitioners till the disposal of the instant revisional application. The learned তার আগে লিখে দেবেন এটা বলার আগে heard the submission of learned advocate representing the state. Who is present? You are present with the case diary. Who is present with the case diary? There's nothing against him.
164, there is nothing, but in the complaint, there is something.
Nothing can be aware. Why just bother them? A copy of this order to be communicated to the trial court by the department at once. Next.
Well, matter to appear, Malad. Let there be a
Yes.
principal date.
Next date we fixed on 8th of December. Next.
498, 406 compromised.
Compromised.
Wife is with me now. Now she has come back to me.
So what to do? You want to withdraw?
No. Quashing of the proceeding. The 498 and 406 by my wife. Now we have settled, agreement has been done.
Okay,
He
the
has
learned
withdrawn.
advocate representing the petitioner has been submitted. The dispute between the petitioner and the opposite party wife has been resolved. First up, the opposite party wife has resumed cohabitation with the husband in her matrimonial house. Full stop. The learned advocate representing the state is to file a status report on the next date of hearing. Next date be fixed on 9th of December. Who will appear? You will appear. So, learned advocate, Miss. Shreyoshi Bishash, who generally, today I got your name right. There has been a gap, so got interchanged. Who generally represents the state is requested to appear on behalf of the state. She is to be present on the next date of hearing along with the status report and the
Record 161 of the de facto.
yes, status report and the case diary with necessary steps taken in the light of the submission of learned advocate representing the petitioner. Next day, কত বললাম?
27.
Let a copy be served upon
A
me.
copy of the revisional application along with the annexures be served upon the learned advocate representing the state. Next date be fixed on. You get it resolved as early as possible. 7th of November.
Proceeding is going on against me.
9th December. No. Now, if the proceeding is going on, nothing will happen.
Charge sheet will be sir.
So what? Now she will take care. Next, you take care, madam.
She'll take care of the wife.
She'll take care of the proceedings.
Proceeding. Wife, I'll take care.
Next.
Grateful.
Kuni? None appear to represent either of the parties. Next date be fixed on 10th of November. Next.
Take please.
And they are doing a trying to expose the petitioners from the petitioners. And to the still they petitioners lost several jobs. And last thing, around 20 September 2024, when the petitioner made another complaint, complaining about the harassment they committed. But against the petitioner was brought by the police station. After that, after attending the police station, which particular, but come back and not within 10 days, now this one against the petitioner. And then in this is the charge. When then the people got the complaint, page 23.
Yes, when then you need the presence of the state also. Let the state be there. You issue, serve notice and then comes. So this seems to be going on since long. Then okay, let the state be present. Acha, heard the submission of learned advocate representing the petitioner. Madam, you be there. You be there in this matter. You ask the police to be present along with the case diary on the next date. Okay. The learned advocate, Ms. Shreyashi Bishash, who generally represents the state, is requested to appear on behalf of the state. She is to ask the investigating officer to be present before the court along with the case diary on the next date of hearing. Next date we fixed on 22nd of September.
In the meantime, he shall serve a copy upon me.
The learned advocate representing the petitioner is to serve a copy of the revisional application along with the annexures upon the learned advocate representing the state and other opposite parties. The learned advocate representing the petitioner is to further serve notice upon the opposite parties apart from the state, intimating the next date of hearing and file an affidavit of service to them. Next. Yes. So you were listening to the other case just yes. Let her come with the case diary. No, I'll ask her to bring the case diary within 2 to 3 days on Monday. Since nobody is there, you.
Let Mr. Sinha's name be recorded. But I shall inform him.
And, I don't find Mr. Sinha here today. You are there, you do it. We've heard the submission of learned advocate representing the petitioner. তারপরে we আগের অর্ডারটা যা ছিল না, we'll see. You come with you ask the
IO to be present.
IO to get the case ready. Yes. Next date, 22nd September. None appear to represent either of the parties. Next date be fixed on 6th of November. Yes. What is it? Who asked you to be so proactive? If at all you did not have any other motive. Page? Wait. The shop room is under your possession. You are simpletons. So you went and shown your might. No, you were playing caroms also. You were playing carom, you demanded money. You said, unless and until you give us money, we will not allow you to open the, function the shop. Which page? So all the other shop owners ganged against him. What?
There are 6 shops, but the developer have sold 8 shops. Now there is an issue in demand. Now they want to create a.
Yes, but they have said. Report filed on which date? But the report says, hence necessary order may kindly be passed to lodge FIR against Mintu Mal. So then what is I? No, but you refer to this page, right?
Prior to the FIR was contract, registered under abatement 323 and 385. That is 2 extras. Because CBD between the owners of the shop and the developer.
Was there any possibility that construction could have been done above, on and above the shop?
It's a BD. So BD is
But then lastly, when the petitioner and the other six shop owners were trying to do the construction work.
basically partitioning the area.
Okay.
There are 6 shops. The developer has sold each. Now there are dispute between owners and the owner to demarcate the shop. Because I am a local person, I was paying for. I overstepped my rights, my lord. Hence, my lord.
To be a hero. How you face the consequences?
But I have faced the consequences. I've gone to court. There's no cognizable offense. Nothing is. Lordship is seen.
Go and catch up with that fellow.
Very difficult. But let me serve. Let him come. Lordship. Thanks.
No. You initiate the process because it is quite good. No. You initiate the process because you have ruffled him to such an extent that he has become too obstinate. The learned advocate representing the petitioner is to serve notice upon the opposite parties. So the complaint is filed by the wife. Serve notice upon the opposite parties, intimating the next date of hearing, and file an affidavit service to the defect. Next date be fixed on 12th of November. No, what is the next date fixed? Then again you be there. So you've asked them to be there? No. Without hearing you, yes, because
after vacation.
no, you place the CD and then maybe we'll see. They'll learn over appointment to Korea. When notice to serve only upon the opposite party. Number 2, or appointment to Korean. Yeah, I know. You have to serve notice upon the de facto only because she is being engaged. Next date we fix on 23rd of September. You ask the IO. Yes. Yes, that will be served copy. Next.
The IO has to be.
Sorry? Not today.
That's why I'm also the Supreme Department take where that case were not followed. Thereafter, followed this case and strategies completely protection savings. There is it is judgment of the strategy kind of life. And not that
I am in. Or kindly system or first information report. Totally our date and our total our last 4 weeks.
Your how many petitioners are there?
That I in spite of this of anything that Rakesh data or PL government export had deliberately made any payment from 2011 or I made that's why our volume and volume entire our receipt that our added
The investigation has been completed. That sheet has. Wait, sir. Wait, let me go through the complaint once. So let me just. So the transaction was to the extent of 1,99,53,000.
Even more than that.
You have not paid a single penny. In spite of assurance regarding regular payments to a company for supply of the said goods, till date, the said Rakesh Dhadich, the petitioner, made no payment to our company against the above bills. Hence, it is clearly palpable and glaring that Rakesh Dhadich, since inception, has an intention of chief in spite of race of delivery fatum.
Right hand side are empty because we are trading private limited. The defect of them. Thereafter, one was page 26. Page 26. Last entry, 15 December at the bottom. 15 December 2014, the right hand side. Local we are trading 2014. Thereafter, one was I declared a 40 or 12. Second volume. Entire payment has about
200 and
12.
one lakh, 135,844.
5 lakhs 84,000.
You have paid.
Yes, ma'am. Our total false allegation is an FIR has to lodge.
No, but then wait. In the complaint, did they mention the date from which you had entered into this with the companies at mainly from, they are saying from 2018 to 2024.
I have given check. That date was expired, that's why case has been started and used for a trading.
Which check?
The security check, I have given for 240. I have.
So you mean to say that though you had given them these checks,
Security purpose, I have given, that date was expired, that's why this case has been. They could not initiate 138 closely because for this check rate expired. Otherwise, it will be. That's why this case has started.
where is which is a court in which it is pending? No, I have understood, but then, you serve notice, sir. No, I'll ask her to as early as possible. Which police station? Which police station? The complaint was lodged on which date? June. What is the date of this notice? Huh? When were you notice? Dated? Date is not mentioned. Date? It is 3 days. Yes, when did you receive this notice? No. The learned advocate representing the petitioner submitted the complainant to have lodged a false complaint against the petitioner stating that a sum of rupees 1 crore 9,53,896 was not paid by the petitioner to the complainant since 2000 against certain transactions for supply for delivery of supply and delivery of yarn and yarn products to the petitioner on credit basis against bills and invoices raised against such supply and delivery of goods, mainly from the year 2018 to 2024. Based on such complaint, Robinder Sarobar Police Station case number 64 dated 066/2025 under section 318 bracketed 4 / 316 bracketed 2 of BNS had been instituted. The learned advocate representing the petitioner further submitted that a sum of rupees 1,39 lakh approximately had been paid to the petitioner through bank transaction. Through bank transaction. Full stop. The police had been seeking the presence of the petitioner by issuing notice under section 35(3) of the BNSS. This is the first time. No, but then if it is a reminder one, that means you did not comply with that notice. Which notice which had been harassive in nature, since the petitioner, in compliance with the earlier notice served under section 35(3) of the BNSS, had produced certain documents which the investigating officer refused to accept, and subsequently issued another notice under section 35(3) of BNSS. Full stop. The learned advocate, Onar naam diye, Ms. Sheoshi Bishas, present in court, who generally represents the state, is requested to appear on behalf of the state. Full stop. The learned advocate representing the petitioner is to serve a copy of the petition upon the learned advocate representing the state, who is to seek the presence of the investigating officer along with the court case diary before this court on the next date of hearing. The learned advocate representing the petitioner is to serve notice upon the opposite party. Number 2, intimating the next date of hearing and file an affidavit of service to that effect. Next date we fixed on 22nd of September. Or else it is of which thana? Here only. So you can ask them to be present on 16th of September. 16th of September. The learned advocate representing the state is to instruct the concerned police station not to initiate any coercive steps against the petitioner till 16th of September. আর কিছু নেই তো?